Well, Your Honor, we live in kind of a new time, the era of Murdoch. And when I began practicing law in the 70s and the 80s and the 90s, we used a time-honored device in high-profile cases, sequestration of the jury. Now, we did not move for sequestration, nor did you choose to do that, Your Honor, and we respect that decision. But at this juncture, Your Honor, this case has garnered so much publicity, so much, I think I can't understate the polarization in this community about this case, and that's for a variety of reasons that I've submitted to you and would ask to make as a court exhibit several pieces of paper. One is simply a photograph that was posted on Instagram, I believe, and it is one of the more tame. I am told, though I'm not, I don't cruise the internet, certainly not during a trial, but I am told that there are TikTok messages that if there's not a conviction in this case, that the courthouse will burn. I know that that's of concern to everyone. There are, yesterday, the third piece of paper, which is a dark text message, was received by a member of my client's family, and they sent it to me immediately and made no response to it. But it's alarming because it represents the other polar, what I would call the skinhead white supremacist, that lunatic fringe. And Your Honor, in the middle, as we have said, the narrative in this case, beginning shortly after the incident, hasn't been helped by the statements of public officials. I've attached that, but it's already a part of your record elsewhere. And then I've highlighted a portion of a news article, which I won't read because I've highlighted it for you, but it suggests that somehow this trial, instead of being a fact-finding mission resulting in a neutral, detached jury's deliberation and determination of guilt or innocence, is somehow a moratorium, and that justice will fail if the event that this journalist seemed to suggest is the result that should be obtained. But, Your Honor, for all of those reasons, we rely on judges' instructions. We hope, we keep our fingers crossed that juries will take that to heart, that they will avoid interference, that they will report it to the court. But we know from the Murdoch case, that just doesn't happen. Now, that case is different because it involved the interference of a court official, one who, as our Supreme Court said in that opinion, was the court's representative. So the jurors could have easily felt, as they did in that case, that it was okay because that was the court's caretaker. But I think that there is the very real potential, given the amount of publicity attendant to this thing, Your Honor, that I would ask the court, though it is inconvenient, it will take 10 minutes, and I would not oppose you, Your Honor, going to the jury room and pulling them one at a time out in the hall. I don't know that we even need to be present. I don't know that the prosecution will have a position on this, but I do think it's important not to poll them as a group. I think it merits, in order to assure a fair trial that is free from any taint, interference, suggestion, even to the extent of driving by the state capitol this week, you're likely to have seen a poster. And I don't want jurors to think that they're getting themselves in trouble if they have seen something that may have caused them to think in an inappropriate way. But I do ask, Your Honor, with all respect for the time and the economy of time, but I think it is that important. Thank you.
State position.
Your Honor, I don't think we need to bring any additional attention to this matter, Judge. I mean, the things that Mr. McCullough has brought out, I mean, I appreciate the fact that he brought it to our attention, but we can't control what the outside world does. And I mean, posts by people who are not involved in this case, that we had admonitions that were given, and to our knowledge and what we know is the family's done everything they're supposed to do. They've not posted, they've not engaged, they've not done any of the things that the court has asked them not to do. What the rest of the world does outside of this courtroom is what the rest of the world does. What the rest of the world calls us, calls prosecutors, I really don't care. You know, we're here to do justice, and that's why we're here now. To ask the jury to do something additional now, Judge, If they've got a question, they have the ability to write it down. They got the ability to say, hey, Judge, this did or didn't occur or whatever. And to my knowledge, that's not taking place. So in order to pull them out and to start kind of poking and asking, specific questions of them, I just don't think it's proper at this point. We've had other high-profile cases. We've not done it. We didn't do it in the Uber case here. We didn't do it. I mean, it's not been done that I can recollect. I'm not almost 30 years of practice in law. I've not had a case where that's happened, and I don't think that we need to start doing it now. If the jury has a question, they understand your admonitions. These are grown folks who went through the process. They've adhered to everything that you've asked them to do at this point, and there's no need to start pulling them out and searching for something when they're not telling you that anything is going on. I don't think it's proper right now.
Your Honor, I would simply say that as I mentioned, we sequestered juries for many decades. And we did so at a time when the only access that jurors could have to taint themselves were much less than today. There were 3 TV stations. There was no internet. There was no social media. There were neighbors. And those opportunities were the only opportunities to be tainted by public opinion. And yet, for 3 decades or 4, our courts sequestered juries. To the best of my knowledge, we stopped doing that because of the expense. Okay, I get it. But today, 1,000 television channels, social media platforms that allow the worst and most scurrilous, degrading, disgusting conversations, even to the point of threats of violence and threats of destruction, that is so ubiquitous, Your Honor. And I think, I don't know that I recall making a motion like this, but having gone through the crucible of the Murdaugh case, I recognize a couple of things. The frailty of a jury's willingness to come forward. And that's a human nature. It's not a dishonesty on the part of the jury. It's just a belief that it doesn't need to be reported. So I would ask again, Your Honor, while it may be novel, but I think it is necessary. And the mere fact that it hasn't been asked before of you or another judge, whether in this courtroom or another, I don't hesitate or have any embarrassment about asking you to do it now to ensure against the possibility that any juror has been contacted or otherwise stumbled in to the receipt of information. Thank you.
All right, well, I'm on your position on that, Mr. McCullough. I don't think there's any real procedure for doing that, and I see it as fraught on a number of levels. If I were to go back there and examine each juror individually myself, again, based on what we learned from the court's ruling in Murdaugh, I am hesitant to have any sort of conversation off the record outside the presence of all the lawyers with any juror. So I will deny your motion in that regard. What I am going to say, though, too, is the stuff here that you provided is troubling, although there's been a lot of troubling things all weekend. Lawyers, and I guess I'm more talking to the public here, we just all need to turn the temperature down, much like I cautioned the lawyers Wednesday to turn the temperature down. The public does too. This matter is actually only a matter of life or death with the Carmack-Belton family and the Chow family. The rest of the folks don't need to be sending messages like this to lawyers. I actually got emails myself over the weekend, which reminds me I need to send a sled. Please, folks, just turn the temperature down. There will be a verdict maybe here today, and we're all going to be respectful of one another. And I want to commend everybody that's been in this courtroom for the week, or all last week. Everyone here has been respectful to one another. There have been no issues, there have been no outbursts, and I commend you all on that for being respectful of your neighbor. But we're going to continue to do that, and that's how today's going to play out. So, with that being said, what else? Jury charges.
Yes, Your Honor. I think we just have 2 quick issues to bring up with regard to what the defense's position is with final charges. We did send an email to the court yesterday afternoon with the 1 edit and the 1 addition. First of those would be to add within the element about bringing on the difficulty. Our position is that the language and the court's draft, the cleanest way to make this edit would be at the bottom of 16 going into 17, that if the conduct of the person defended or the defendant was unlawful and of the type which was reasonably calculated to and did provoke a deadly assault, and continuing from there. In support of that language, we're relying on State versus Bryant, 336 South Carolina 340. That's from 1999, and that exact language was reiterated in Slater, and that's 373 South Carolina 66. And the direct quote from those cases is that any act of the accused in violation of law and reasonably calculated to produce the occasion amounts to bringing on the difficulty, and would bar his right to assert self-defense if those conjunctive conditions are met. So that would be the first request that we'd have. And we also do believe that the evidence adduced over the course of this trial does squarely put the issue of withdrawal in front of the jury, and that is a question that they must decide whether. I don't think it's going to be any surprise that the state will argue that Andy Chow and or Rick Chow were at fault in bringing on this difficulty. With respect to the testimony that we have received over the course of last week, Andy's conduct, his act, the jury could find that act amounts to a withdrawal from any potential difficulty the jury may have found he had brought on. And if that withdrawal was effective, then his right to self-defense, and by extension, Mr. Chow's right to defend him, would be restored. And in support of that withdrawal charge, the language of which is one's right to self-defense is restored after a withdrawal from the initial difficulty with the victim, if that withdrawal is communicated to the victim by word or act. And that or act portion was emphasized, I believe, in State versus McCarty. That's 437 South Carolina 355. And that is also quoting the Bryant case at 336 South Carolina 340. We do believe that the withdrawal law does need to be charged to this jury in light of what's been adduced over the course of last week.
Continue to state.
I just don't recall any testimony regarding any withdrawal. This was one continuous act, Your Honor. I don't remember any testimony whatsoever of withdrawal. It was a chase that went 130 yards, and there was some backing up that was testified to, but it was right at that moment. This was a bam-bam kind of situation, the way it was described.
Okay. Here's what I'm gonna do. I did look at all this. As far as the violation of the law language, I'm not gonna charge on that. I think the implication of that charge would mean that there would have to be a violation of the law for someone to be not without fault. So I'm not gonna put that in there. I am gonna add the language of withdrawal, and it is in the final charge. It would be on page 18 at the bottom. And here's the exact language. And it went a little further than what you asked for, Mr. Copeland, because I think you sort of cut it all short. Here's the exact language. One right to self-defense or defense of others is restored after withdrawal from the initial difficulty with the victim, if that withdrawal is communicated to the victim by word or act. Withdrawal from a conflict must be effectively communicated to the victim by word or act to restore the right to use self-defense or defense of others. An accused who provokes or initiates an assault cannot claim self-defense or defense of others unless the person defended both withdraws from the conflict and communicates his withdrawal by word or act to his adversary. So went a little further, okay, then just, I guess you pretty much had the first sentence, but the model charge that we have added, basically it has to be essentially unequivocal that the person defendant is withdrawing. So that's how I'm gonna do it. Y'all have been emailed a copy of the final charge as well. Anything else?
Are you intending on, or have you thought about, we're gonna send the instructions back with them initially, or just play it by
I
ear?
typically do not, and I will let them know that if they have a question about the law, the procedure for that would be to send me a note, and then I can recharge them on the law. I just get concerned that folk, this is intended to be interpreted as a whole, and I get concerned that folks, one person relies solely on page 17 and nothing else as a whole. I don't know whether I'm right or wrong. I know some of my colleagues send the charge back, but that's the way I am. All right, we ready for closing?
Yeah, a little PowerPoint here that's just gonna have some, so Pat has the thing ready whenever, I know it takes a little time to fire up.
Okay.
Pat, if we have it, will it just turn right on whenever we're ready for the first line? It just
It has a little delay, so,
okay.
yeah.
And as you can tell, the document you gave me, you did one to the court reporter, you marked this court on.
I did not, Your Honor, I just passed it up to you, but I'll be happy to come up and hand it out.
We made this one court tonight. All right, we're ready.
Yes, sir.
All right, making sure, please, sir. Yes, sir.
Jury seated, Your Honor.
Thank you, sir. Good morning, ladies and gentlemen. Good morning. The parties have presented all the evidence in the case, and it's now time for the attorneys to make their closing arguments. Much like the opening statements, the arguments of the attorneys are not evidence in the case. Their statements are meant to help you understand the evidence
We are, yeah. May I please go?
Yes, sir.
What is the value of a human life? That's usually posed as a rhetorical question, isn't it? What is the value of a human life? Can we assign a monetary value to a human life, to a human soul? Can we put a price on it like we can a bottle of water, or a bottle of motor oil, or a lampshade, or a fishing boat? Is that possible? Are some lives worth more than others? These are philosophical questions that people have been wondering aloud for ages. Do you remember that feeling of being a teenager? You remember what it was like when your body was new and shiny? You remember that? Remember a time before work and bills and all the responsibility, being responsible for other people? You remember that feeling? You remember what it was like having that long road of life just stretched out before you, and all the possibilities. Not knowing what they were, but just being excited for the ride. You remember that? Remember the last day of school? Remember the beginning of summer break, sleeping in, summer jobs, fireflies, fresh peaches? What about grandma's house? Slip and slides? Remember the smell of fresh cut grass? Beach trips, no responsibilities. How do you put a price on that? You remember that? How do you put a value on that? I've got a 15-year-old daughter and an 18-year-old son, and they're in that time of life. And if I'm waxing too poetic, it's because I'm envious at times of them, and being in that stage, and just having that whole long road of life stretched out before you, and all the possibilities. Just an adventure waiting to unfurl, right? But if I could jump in a time machine and go back to them being 14 years old, I don't think I would, because I remember the difficulties of that time as well. I remember being 14, and a sad reminder that I'm not anymore is sometimes when I get a glimpse of the camera and I see my face up there, and I say, who the hell is that? Where did those wrinkles come from? Where did that gray hair come from? But I do remember being a 14-year-old boy. And if I could, I don't think I'd go back to being a 14-year-old boy, because I remember the difficulties of being a 14-year-old boy. I remember the idea of trying to zero in on what is my identity? What is my personality anyway? Who am I? Where do I fit in? How can I be cool? And to this day, I still remember things that I did that made me shake my head, things that I strongly regret, things that were ill-advised, things that were reckless and dangerous, things that were just plain stupid. It was not easy being a 14-year-old boy, and that was back in 1993. But that's what being a kid is. That's what being a 14-year-old boy is, to make mistakes and hopefully to learn from them, right? Isn't that what growing up is supposed to be about? I didn't look much like Cyrus, and I think that's obvious to everybody here. We grew up in different parts of Columbia. We had different experiences. We went to different schools. We grew up under different circumstances, different times. Seems that we were both skinny little 14-year-old boys from divorced parents trying to find our way. I remember trying to straddle that line between being a child and trying to figure out what it meant and where my place was in the world, and trying to figure out how to be a teenager. Trying to figure things out. And as I said, it seems that to me that it would be infinitely more difficult to be a 14-year-old in 2023 than it was in 1993. There are just things that exist now that were unimaginable back then when I was 14. But some of the broader challenges would have been the same. Where do I fit in? How do I fit in? This would have been that wistful time of life for Cyrus in May of 2023. He had just wrapped up 8th grade. We all know what comes next, 9th grade and high school and all the craziness of that. But right now, May of 2023, it's summertime. The first week of summer. What's better than that? How do you put a price on that? It's the best time of the year for a kid. There's still a few months before he has to deal with that crazy time of 9th grade and high school. Sunday, May 28, 2023, it was Memorial Day weekend. Cyrus was fresh off middle school graduation, and it was summertime. Why does a 14-year-old have a gun? This was asked multiple times by my friend, known him since I was 14, Jack Swirling. But he asked that a number of times. And I suppose he asked that as a literal question that deserved an immediate, succinct, distilled, and simple answer. That was how the question was posed, that it is a very simple question and deserves a simple answer. Maybe it's not that simple, though. Maybe it's a much broader question that we as a society will eventually have to sit down and come up with real answers to and possible solutions to. Maybe it's a question with an answer that is so complex, it has so many layers, that it's so loaded that maybe it's not something we just figure out in a day. But it does seem, as long as guns have existed, boys have been fascinated by them. Required reading when I was in elementary school was Where the Red Fern Grows. And it was all about Billy and his gun and the exploits and the adventures of 10-year-old Billy and his rifle. Or, my favorite movies back then were Tombstone and Young Guns and Predator. Terminator. Just movies about guns and violence. Boys eat it up. I did. So many movies, so much imagery, so many music videos about guns. It's just, we're in America. It's part of life, and boys eat it up. You can't even get through December without Christmas Story and Ralphie and his fascination with the Red Ryder rifle, right? It's just a fact of life. And that was all before the internet. But again, we live in America, and to take that one step further, Cyrus and I grew up in the South. And we were blessed to grow up in the South, weren't we? And guns are just a part of life, are they not? A gun leaning up in the corner when I was growing up was about as exciting as a cast iron skillet on the stove or a butcher knife in the sink. It's just part of our life. And whether that's good or bad, I'm not here to talk about that, but guns are prevalent, and boys gravitate towards guns, whether that's good or not. Was Cyrus right in having a pistol in his pocket May 28, 2023? No. Was it legal for Cyrus to have a pistol in his pocket May 28, 2023? No. Has anybody indicated that it was okay or legal or right? No. Did he deserve to die? Did he deserve to die? I remember my grandfather letting me practice with a little .22 rifle. I remember being 8 shooting a .22 rifle. I remember my first single shot, .410 shotgun. I was probably about 12, 13 when I got that. I remember going up to the little cabinet just off the kitchen in my grandparents' house and finding a little revolver he had there. And I remember taking it down, and I remember going down to the pond and shooting a few shots. I was probably about 12, and I knew I wasn't supposed to do that. And I knew I'd get in trouble if I got caught. That didn't stop me. I remember all those things. Boys do things that are ill-advised and not always smart. That's part of life, though. We hope as we grow older, we learn some of these things, and we grow out of them. Did Cyrus deserve to die? When Cyrus Carmack-Belton entered that Shell gas station at 7441 Park Lane Road, about 8 p.m., May 28, 2023, he had no way of knowing that he'd be dead in about 10 minutes. You see him enter the gas station. He is immediately asked to take his book bag off. A very fair request, and he complies immediately. He's not rude during the encounter. He does as he's asked to do. We see Alice check the facial recognition database once he comes in. We heard about the facial recognition database they employ at the Shell gas station. And then she went about her business, or pretended to act busy, while keeping an eye on Cyrus as he walked up and down the aisles. At some point she ducks her head into the office where Rick is. What, if anything, she said to him is unknown. We don't know. But Alice and Andy continued to watch Cyrus as he walks up and down the aisles. Eventually he goes to where the water bottles are. He had to know he was being watched, right? I mean, I don't think Alice was making it unknown, or she wasn't really disguising what she was doing. He took 4 bottles of water out, put 4 bottles of water back in. He's caught on camera from several different angles doing so. And cameras do not lie. Cameras do not make mistakes. It would have taken about 17 seconds to watch him at that water cooler if Rick Chow had decided to do that. About 17 seconds of his time. 17 seconds to confirm that he took nothing. Failure of Rick Chow to do this will cost Cyrus his life. Thousands and thousands of dollars of technology at Rick Chow's fingertips, and he chooses to act in anger. Cyrus would be a rising senior if he was still alive, entering his 12th grade year of high school. If Rick Chow had taken about 17 minutes to review the footage. 1, 2, 3, 4. 4, 3, 2, 1. As Cyrus turns from the water cooler, Alice and Andy begin asking him if he put a bottle of water in his pocket. $1, 114 pounds, 130 yards, 21 grams. Fight or flight. You've heard that term. It's a physiological reaction, right? It's ingrained in us since we were cavemen, I guess, basically. And it is an instinct. It's a reaction that occurs in situations where there is a threat. Okay. If Cyrus is a tough guy, right? If Cyrus is a thug, right? If Cyrus is a gunslinger, right? If he is that guy, okay? If he's that guy, now is the time you'd see it. Now's the time he'd pull that pistol out, point it, if he was that guy, right? He's not that guy. He's a child. He doesn't pull out his pistol. He doesn't cuss or disrespect anyone. He collects his backpack, and drops his head, and he walks out. If he was a fighter, now would be the chance for him to confront anybody. If he ever intended to use the gun, it would have been right here. But this is the moment where cool heads should prevail. Cool reflection should be what happened here. Reflection should have occurred. This is when adults should act like adults. This could have been it. He could have walked off. He would be a kid looking forward to senior year in high school. You have a mother and a father who would still have their little boy. $1, 114 pounds, 17 seconds, 1 second, 21 grams. An entire lifetime ahead, unknown potential, success, failure, redemption, decisions. We know the decision Rick Chow made. It's etched in time now. It plays back like a bad movie you've seen before. You already know the ending. He did what he did, and that's why we're all here today. Let him go. Just let him go. We don't need to be here today. Let the boy go. What have you got to lose? What is the value of human life? As of May 28, 2023, Rick Chow had owned and operated that gas station for over 10 years. This was not his first day on the job. Why not call 911? It takes 1 second. Andy said so himself. It takes 1 second to call 911. Better yet, why don't we review the videotape? If we think the boy took something, why don't we look at that videotape? Because then we'd realize we don't even need to call 911. He never did anything. We would have learned that immediately. All this at your fingertips. Instead, you choose to act in anger. You choose to make split-second decisions. And you're dead wrong. For argument's sake there, let's say he had committed the abominable crime of stealing $1 bottle of water. Let's say he did that, okay? Well,
You remember the wall of shame? You remember the testimony about all the pictures all over the store of various people who had been suspected of shoplifting. And what we do at the Shell gas station is we take their picture, because we have all these cameras that we can get all these pictures from, and then we put it up on the wall of shame. And that's what we do. We shame them. But also, if they come back in, we can confront them. Why don't we put this little boy's picture up there then? I mean, if he stole water, let's just do that. That would have been a better option, right? Or, we get all these pictures, let's send them into law enforcement. Looking for this guy, and by the way, we know exactly what he was wearing, and by the way, he walked that way down this dead-end road. Shouldn't be too hard for you guys to solve. Anything would have been better than this. He chose to chase down an 8th grader. The boy was so terrified that he ran out of his shoe and continued running. The boy was so terrified, he's losing clothing. He drops his phone. He drops his mother's phone. But he continues running. But wouldn't that have been even another great opportunity for them to stop? Listen, we've scared this little boy so bad he's come out of his shoe. Let's stop the insanity right here. Let's turn around, let's take our butts back to the Shell gas station. What are we even doing anyway? Why are we doing this? But no, they continue tracking him, chasing the boy down. And then he takes that hard fall, hits the ground. What about right then? Wouldn't that have been a good time to be like, we're scaring this boy so bad that he's run out of his shoes, he's lost his cell phone, so now he's hurt himself. We've gone too far. We've gone too far. But no. 130 yards, 114 pounds, 390 feet, 1 second, 17 seconds, 21 grams. Why in God's name are 2 grown men, one armed, chasing a child, because that's what he is, 130 yards? Why in God's name? Devontae Bryant, he had to hit the brakes because he didn't want to hit him. They'll come running out in front of him on Springtree. Dead set on catching that boy. He had to put the brakes on. He says he thought it was the police. I said, well, why'd you think that? He said, because one of the guys had a pistol. And they were chasing that boy. I thought that was the police. And so that would have been what Cyrus saw too. He doesn't know why these men are chasing him to begin with, why they're yelling at him. And now he sees one of them has a gun. And he's wondering, why are these people chasing me? What are they going to do to me? And he's running. And Devontae Bryant said he didn't have anything in his hand. Lori Carson pulled up too. Remember her? That's her in that BMW. A grandmother. She recognized immediately Cyrus was a child. She said he looked frightened. He looked scared. He said it looked like he needed help. He said he didn't have anything in his hand. Kennedy, Jasmine Broadwater, they saw him too. He didn't have anything in his hand. All of them had different angles to observe. None of them knew Cyrus. But they were all very clear. The boy had nothing in his hand. He had a backpack over his left shoulder, which we can see in the video. trying to hold his pants up while he ran from these men, but he had nothing in his hand. What does 130 yards look like? Well, looks like this. It's a long distance. It's too damn long. It's 130 yards too long. 114 pounds, 1 second, $1, 21 grams. Cyrus was shot in his back as he ran away from Rick Chow and Andy Chow. He entered his lower back, just to the right of his backbone. It traveled upwards, you see. It went through his lung, you see. It entered the right ventricle of his heart. It came to rest there. And that trajectory tells us he was trying to get away to the very end, trying to run from danger. He died scared. He died bleeding to death. Rick Chow's face being the last one he saw. He died surrounded by strangers. He died scared on the side of a road in nowhere America. He died young. He died because of Rick Chow. Shot in the back. Today Rick Chow says, well, guys, I had to do it. I had to kill that boy. I had to chase him down and I just had to shoot him. He says his son yelled gun and he had to shoot. He tells you he was justified in doing it. And he says, well, if you're wondering why I shot and killed a child in the back, it's because of the doctrine of defense of others. That's what he says to you today. And he was dead wrong on May 28, 2023, and he's dead wrong today. Okay. So, what is the law of defense of others? There are 4 elements that the state has to disprove one of them, okay? But these are what would get you a charge and find that you would be justified in killing somebody based on the law of defense of others. If any of these are disproven, any one of them are disproven by the state, then he does not get that legal justification for killing. You understand? If you find any of these to not fit for him, he does not get the defense of others. Number 1, okay? I want to be clear. He fails right off the bat. What is the number 1 element of defense of others, the very first one that he fails miserably, Rick Chow and Andy Chow both must be without fault for bringing on the difficulty. Y'all remember those questions I asked Andy? And by the way, the other thing y'all get to consider is credibility of witnesses. Y'all seen people lie before. Y'all seen people tell half-truths. Y'all seen people waver before in questions they didn't really want to answer. Y'all seen that before in life. Y'all have a chance to sit back there and talk about whether y'all found Andy to be a credible witness or not. But one thing I asked him is, Andy, Cyrus is still alive if y'all stay in the gas station, right? He said, yeah, you're right. But then they decided to ramp it up. They brought this difficulty on, okay? One of his lawyers said, well, you know, Cyrus would be alive if he didn't have a gun. And I said, you would never have known he had a gun, would you? If you just kept your butt in the shell station. Kept doing the work you were doing. Stay behind the cash register. And Rick, stay back in the, what do you call it, your surveillance room back there. Why don't you just stay back there? Why are we running 130 yards off our property? Even after he loses his shoes and his cell phone, why aren't we just stopping on the property? If we need to see which direction he goes in, well, we see him running up that straight road, and we know it's a dead end, and we got all these pictures of him. Now we got his cell phone, we got his shoe, we got all these pictures of him, we got his clothing. Cell phone, shoe. Why do we bring on the difficulty when we don't have to? But right off the bat, defense of others fails. Prong number one. A grown man with decades of experience chose to turn suspicion into pursuit and pursuit into gunfire. We fail immediately. But if we were to consider going on, he fails all four of them. Let me just walk you through it just to be clear. But if any one of them fail, he does not get that defense. But number two, Rick Chow must be under the belief or have a good faith belief that Andy Chow was in imminent danger of death or serious bodily injury, harm. We saw that a fall and the after effects of it, it was such a violent fall that it led to those wounds to his shin. He goes face down into the ground with various witnesses said. And then marker AA right there, that would be the laser pointer, the flashlight we heard so much about. But that is an interesting marker because you know what that tells us? A couple things really. It tells us where Cyrus fell and hit the ground, but it also, along with those wounds to his leg, shows us how violent of a fall it was. That would be where he hit the ground, and the only way this works is if his gun comes out of his hoodie, hits the ground so violently it dislodges the flashlight, and that's where it came to rest. Ladies and gentlemen, if you are a 14-year-old boy, and you know you're not supposed to have that gun, and you're being chased by people, and it spills out, the very first thing you're going to do is pick it up and continue running, which is exactly what Cyrus Carmack-Belton did. He was trying to get away. But as you see right there, that would be where he fell. And we know he continued running because his body is found past those two poles. But what is further up towards where his body came to rest? AB right there is that shell casing. That is approximately where Rick Chow stood when he fired the weapon. So even after we see where Cyrus fell, Rick Chow is still advancing towards him, still moving towards where he ultimately came to die. I don't know how you describe being in fear of this boy and being terrified of him, but even after he falls and you supposedly become aware of a gun that spills out of his pocket, you continue to advance towards him. How do you say now that you were in fear of him? And would a reasonably prudent person have done this? Would a reasonably prudent person have even left the Shell station? The answer is no. He fails 2, and he fails 3. So finally, Andy Chow must be shown to have had no other probable way to avoid the danger of death or serious bodily injury than to act the way he did. Okay? I don't understand how you can ever say I'm retreating when you were the one chasing somebody, chasing them off your property, chasing them 130 yards down a road that you don't belong on. How do you then say I was retreating? No, you are advancing. You were the one bringing on this difficulty. You started it and you're the one who continues it. Rick Chow fails all 4 prongs of defense of others, and he fails spectacularly. We only have to prove one. Number 1, he fails right off the bat. I submit to you he fails all 4. This would be a shot by now. You know, we spent a lot of time, I know it's been boring at times, trying to orient you guys with the landscape, but it is important really to kind of have a general familiarity with this area we're talking about. But if we're looking at this picture, which is an evidence, y'all seen those poles right there a number of times. That's kind of a good marker. You've seen this drainage ditch right here on the bottom where the backpack was found. That's another good marker. Behind us would be the Shell gas station at Park Lane Road, and forward is just the dead end. This would be approximately where that laser flashlight attachment would be found. And again, that's where reason tells us that Cyrus fell. And the gun apparently hit the ground hard enough to detach the laser flashlight. That's where that was found. A little bit further up again, past where he fell, that means Rick Chow is still advancing past where that boy fell and continued chasing him with his gun. That's where the casing's found, right there, the green area. Behind those trees, there's Bradford Bears right there. That is where, we know from the body camera, that's where Cyrus comes to rest. That's where he dies. I mean, just on the side of the road, nowhere, South Carolina. Shot on the side of the road like a dog. Surrounded by strangers. Mother not there. Grandma not there. Scared and alone. Murder is, in South Carolina, statutorily defined as the killing of another person with malice aforethought. Okay? What is malice aforethought? The judge is going to define malice for you. This is malice. You see this right here? Y'all see that? Look at it. This is what malice looks like right here. It's hatred, ill will, or hostility. We know how Rick Chow feels about shoplifters. Okay? He has devoted a large amount of space in his store to advertise shoplifters and identify shoplifters. He doesn't like them. Malice is ill will or hostility towards another person. It's the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury under circumstances the law will infer an evil intent. When does malice need to form, and when does it need to exist in the mind of Rick Chow? The judge will tell you it does not, malice forethought does not require that malice exists for any particular time before the act is committed, but it must exist in the mind of the defendant just before and at the time of the shooting. Okay? Therefore, there must be a combination of the evil intent, the prior intent, i.e. chasing a boy up the road with a gun at your side, and the act, shooting. How can malice be shown? There are two types of ways it can be shown. It can be expressed or it can be inferred. They're not different, but just the way they may be shown. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. Malice can be inferred from conduct showing a total disregard for human life. This is malice right here. Y'all see malice? This is what malice looks like. Shot to the back tells the story better than any witness ever could. The state must prove their case beyond a reasonable doubt. This is the standard of every criminal case from here to Seattle, all across the U.S. The state must prove its case beyond a reasonable doubt. What does that mean? Does it mean beyond all doubt? Does the state have to prove a case that leaves everyone saying, I have no doubt about anything anymore? No. It means that if you have a doubt that is reasonable, whether he's guilty or not, do you have a doubt that he's guilty? If you do, is it reasonable? Is it based on logic? If it is, then you should find him not guilty. That's just the law. That's how it's always been. But if your doubt as to whether or not he did what he did is not reasonable, or your doubt is not really logical, you must find him guilty. Does that mean you have to be 100% certain about everything regarding this case? It does not. The judge will tell you there are very few things in this world we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. He's going to say, if based on your consideration of evidence, you are firmly convinced. I put that in bold because to me, it's the best way to understand beyond a reasonable doubt. When you go back there and y'all are talking about issues or what you remember about specifics of the case, just ask yourself, are we firmly convinced? Let's all take a poll. Are we firmly convinced of his guilt? And if everybody raises their hand, then you find him guilty. That is how you determine whether or not there's reasonable doubt or whether there's proof beyond a reasonable doubt. Are we all firmly convinced? Remember those two words. He's going to say it twice when he reads those instructions to you. Firmly convinced. So when y'all get back there and y'all say, what was reasonable doubt again? You say, well, I remember Dale saying firmly convinced. That was what we have to decide. Are we firmly convinced? Cyrus will forever be 14 years old. It'll always be the beginning of summer. Ninth grade in high school, they'll never come. You won't get the chance to catch the eye of a pretty girl. He won't get to feel rejection either. He won't be at the prom with his classmates. He won't have a chance to be cool or to take that winning shot. He won't have the opportunity to be a loser. He'll never get the chance to figure things out. He'll never feel his grandmother's kiss on his forehead. He won't get to drink that beer when he turns 21. He'll never catch snowflakes on his tongue again. He won't get to feel the sun on his face that first warm day of spring. He'll never get to find his way in this world that can be so cruel, but so beautiful. He won't be like this 14-year-old boy and look in the mirror and see these wrinkles and this gray hair that just kind of came out of nowhere, and be able to trace them and think back of the memories and the experiences behind them. He'll forever be 14, alone and scared, running up that road, trying to get somewhere safe, but never making it. And solicitor Stephanie and Weston and I, we walked that stretch of road on Spring Tree a dozen times or more. The air, it just feels heavier. The energy it's off. The tragedy of a life cut short is just burned into the surroundings. I can't explain it. And the question isn't, why does a 14-year-old have a gun? It's, why is an armed 57-year-old man chasing a boy 130 yards, knowing how scared he is, and then shooting him in the back? You know this is wrong. You know it's wrong. They were dead wrong about that water. Mr. Chow, Rick Chow, is dead wrong about this. 14, 130 yards, $1, 1 second, 21 grams. In the early 1900s, there was a doctor. He thought he could measure the weight of a human soul. He thought it was possible to determine the physical weight of a human soul. He measured 6 patients just before and then right after death. And in one of them, he found something interesting. One of the patients, he determined there was a difference of 21 grams. And so he determined, based on that experience, that the human soul weighed 21 grams. 1 out of 6, very small sample size, and it wasn't well documented, but still, it became a popular concept that the human soul weighs 21 grams. We know that's silly today in 2026. What does our spirit weigh? Does it weigh 21 grams? No, we know that's silly. Just like we know a human life, there's no value you can put on it. It's worth way more than silver and gold. It's worth way more than this. You know it. Ladies and gentlemen, you have a decision to make. I thank you for your time and attention this last week and then today. I thank you. There is only one verdict here that speaks the truth. There is only one verdict that addresses what this man did and what this man took away. One verdict. That verdict is guilty. That's what I ask you to do. Find Rick Chow guilty of unjustly taking Cyrus Carmack-Belton's life. Find him guilty. That is the only verdict that speaks the truth and speaks to the evidence in this case. Thank you.
That's right.
All right, yeah, we'll take about a 10-minute break. The technology and stuff sorted out. All right, ladies and gentlemen, we're gonna take a short break. We'll be right back with you, about 10 minutes, and don't discuss the case, or anything of that nature, and we'll see you shortly.
Well, we are continuing our coverage of the murder trial for Rick Chow, and we just finished hearing the closing arguments for the state as they are making their case as to why Rick Chow should be found guilty of the murder of Rick.
All right, we'll be at ease for about 10 minutes.
Now they are taking a quick break right now, and during that time, we have Lacey here, attorney, a local attorney, a very familiar face for all of you as she has been with us through this whole trial. I want to start with the beginning, and the judge opened up, or this, excuse me, the defense opened up this morning asking the judge to question the jurors about whether they saw anything on social media or experienced anything that could influence their decision when it comes to determining a verdict for this case. And give me your thoughts about that, and if this is a normal practice to have the defense say, listen, we want to check with the jurors to see if they, saw anything they weren't supposed to.
So I called it.
Yeah.
I literally said that right before we left on Friday. Attorney Dane Phillips was here, and I looked at him and I said, if you're the defense or the state, are you going to ask the judge to poll the jury on whether or not they were on social media? And he said, absolutely. So we called that on Friday. We knew that was going to happen. And again, it's because, like I said on Friday too, this should have never been put on a trial docket for a short week with a holiday. This should have been put on a docket when it was Monday through Friday. This is a 5-day trial. They may come back with a verdict today, or they're fighting. You may see an Allen charge if they're not agreeing. But I think we should have some type of answer by tomorrow, right? So this should have been a 5-day trial week, Monday through Friday. So whoever's decision that was made the wrong one. And again, that's why I said the defense should ask that question. And again, Joe McCullough, the attorney for the defense, made a great point. We've sequestered witnesses for long periods of time, way before social media, Facebook, Instagram, X, all these things at our fingertips. We didn't have computers in our hands, and I want to say O.J. Simpson's jurors were sequestered, and that was in the early 90s. So I think at a bare minimum, Joe's request was reasonable, and I think the judge should have done it. I think the judge should have been a little harsher on Friday with his instructions. If this were my case, especially with what we just saw with jury influence and the Murdaugh trial being overturned by the Supreme Court, I would have given a very harsh instruction on Friday. I would have said, listen, when you come in on Monday, I'm going to bring you in one by one to ask if you've been on social media and if you have seen anything about this case or read anything. So be prepared. I'm literally asking you just to go the weekend without social media. So I think Judge Taylor should have been a little more strict and harsh in that instruction. And I would have been ahead of it. I am going to.
Yeah.
Instead of sequestering you away from your family and stuff, that's not been asked for the weekend, but I am going to do that. So I absolutely think that was reasonable for the defense to request that, especially with what we've seen. And I think the judge should have, made that a little bit harsher on Friday. And I think he should have asked them.
And what was interesting too is that Joe McCullough presented the judge with several pieces of evidence, if you may, of things that he's seen on social media just about this case. And he spoke to the fact that this has been a very polarizing case for us in the Midlands. It's also one of the most high profile cases that we have seen in recent years here in the Midlands. So many people talking about it on social media. And one of the things that you pointed out is you talked about like the Murdaugh case. And how we saw the jury being influenced there. Well, it was interesting because the judge said, because of the Murdaugh case, I don't want to have any conversations that aren't with lawyers present to question the jurors. So he said that was one of the reasons why he chose to deny that motion. Now I want to switch and talk about closing arguments from the state. You called this as well, that Dale Scott would wear the button up that shows where the bullet went through Cyrus's back and then where it hit his heart. And so talk to me about your takeaways from this closing argument so far.
I said that on Friday that would be very impactful. I would love to know if he planned that or he just heard what I said. I'm just nosy. But I thought that was very impactful. I think it was a little too lengthy. I mean, me and you we were losing track at the end. Closing arguments, and I had this recently in a case, and the closing was like an hour. We don't have that type of attention span, and I honestly think it's worse today because of our phones. I mean, how many of us sit and just watch TV when we get home? We're probably watching TV and scrolling. Right. So that's how limited our attention span is, even more so because of technology. So I think prosecutors don't, and maybe some defense attorneys too, but especially prosecutors, I don't think they think about this. They just want to retry the case in their closing and ramble on and on. Whereas I think Dale was very impactful at the beginning, and he had my attention, but because it was so long, it just lost me. I'm sure it lost several jurors as well. They were probably in and out, kind of, listening to pieces, where I think he could have just hit those strong, powerful points. He could have collapsed this in about 30 minutes and made it way more impactful. I did like the drone. We saw that.
Yes, that was very interesting.
Yeah, where they show how far 130 yards is. I thought that was very helpful. I like the PowerPoint too. One thing we saw at the beginning of the trial is the request to send the jury charges back. And Dane talked about this on Friday. He says that the jury charges should always go back to the jury. I agree, at least put it on a PowerPoint. We all listen in different ways. So the judge said that he is not going to send the jury charges back. He knows some judges do, but he doesn't. And so I think this was a way to really help people understand the jury charges, though, by doing it in closing argument and putting it on a PowerPoint. Dane was saying on Friday he wishes that judges would put the jury charges on a PowerPoint. So putting those charges and what they're about to hear from the judge as far as the instructions on the law on a PowerPoint, and then we saw the X's over, which parts of self-defense that, the defense doesn't have, at least according to the state, I thought was very helpful.
Yeah, absolutely. Now, for folks who are just listening in or who may not completely understand the legal process, talk to us about what exactly jury charges are.
Yeah, so jury charges it's the law, right? It's what the law is, and as we heard from the beginning, the jury is the trier of fact, the judge is the trier of the law, and what that means is the jury is supposed to determine what happened, right? Do they believe that Rick Chow chased him and he was stumbling on the ground and shot him because he stole a water bottle? Or did Cyrus point a gun at his son? So that's what they have to decipher. That is what the jury is figuring it out. And then once they figure out what they believe happened, then they apply the law that the judge just gave them to that. So the judge is going to explain what malice is. The judge is going to explain what self-defense is, what self-defense of others is, what are those elements, right? Because the state has to prove every element beyond a reasonable doubt and disprove self-defense of others as well. So he's going to talk about what that means. He's also going to, most likely, I believe that something will be in there like you can believe part of a witness's testimony, you can believe all of it, you can believe none of it. Like, all those are options. That's our law. And then they can go back and say, I think this witness was telling the truth on this part, but not this part. Now, how do I reason the facts with that and then apply the law? So that's what jury charges are. He will define what murder is, all of the elements of murder, and those types of things, so he can apply the facts to the law of our state.
Thank you so much for breaking that down, because I think that's going to be helpful as we all, the court of opinion, are making what we think is going to happen, the verdict of our own. It's good to know what is the standard, what are the qualifications, what is it that they're going to be making their decision based off of. Now, let's talk about, when we come back, we are going to see the defense make their closing arguments. If you're on the defense team, how are you approaching today's closing arguments?
well, already I think they made the best choice in having Sean Kent do it. I'm pretty sure he's going to do the closing. That's what he is known for. And I think the biggest point that he is going to make is Cyrus having a gun, having a firearm. When he came into the store, he's going to hammer. He had no money. He had a cartridge in his backpack. That's it. You know, they had 2 cell phones, right? Or he dropped 2 cell phones, and neither one of those cell phones had any kind of app for money to pay for anything. So I think that is what he is probably going to center that closing on. And then what I would do is really bring out the emotion. I mean, any parent is going to want to protect their kid, right? So I think he's really going to play up the fact that, you know, their theory of the case is Cyrus was pointing a gun at his son. And I said it before, no matter how old your kid is, that's your baby.
Yeah.
And so I think he's going to play into those parent emotions. You'll do anything to protect your child. And if there is a gun pointed at them, you'll do anything to try to save their life, right? And so I think we're going to see both the gun, the illegal part of Cyrus having the gun, as well as the emotion and a parent protecting their child.
Yes, awesome. Thank you so much. We're going to go ahead and join back in as the judge has just entered the courtroom as we get ready to hear closing arguments from the defense.
All right, you ready?
Yes, Your Honor.
All right, bring in the jury, please, sir.
Whoa, wait on the defendant. Yeah, you go downstairs.
Drew, see you, Your Honor.
Thank you, sir. Mr. Ready?
Yes. May I please report?
Yes, sir.
Solicit. I remember growing up and watching shows with my father. And I'm old enough to date myself a little bit that we would actually listen to radio shows. And one of the radio shows that we would listen to quite often is a guy named Paul Hurley. And what he would do is he would tell stories. And in telling stories, what he would do is tell a story that he thought that everybody actually knew. He would tell a story and he would give details of a story that he thought that everybody actually knew already. And he would tell it, and he would tell it in his interesting way, but what he would do is intentionally leave out parts of the story so that people would be a little confused, because they'd heard the part of the story that they thought that they knew, but he would leave parts out. And then he would take this huge pause after he was done, and everybody would think it was over, and then he would say this famous line. He would say, "And now it's time for the rest of the story." And then he would spend the rest of the show telling the listener the rest of the story that they did not know. He would do this because he understood people. He understood that we are a generation of people who simply listen to headlines, listen to flashy things, and don't hear the rest of the story. He understood that if he could tell just small parts of the story in the way that people thought that they understood them and didn't hear the rest of the story, then they would believe things one certain way. And the way that he did it was fascinating. It was interesting. People started to understand that that's the way we have to start listening. Because if we only hear part of the story, then we can never get to the truth. And so as we sit here and get ready for our closing argument, all we're going to do now is tell you the rest of the story. I will tell you wholeheartedly, and this might come across as a shock, I agree with some of the stuff that the state of South Carolina said. When they got done with their closing argument, folks next to me said, "Do you want to take that dollar down?" And I said, "No." Because let me tell you with unabashed honesty, they are 1,000% right about the following statement. If Rick Chow executed a human being over a $1 bottle of water, enjoy hell. Let's make that clear. If Rick Chow shot a man in the back stealing $1 bottle of water from his store, you do what you will. Because there's nothing to justify this back and forth. Was he right? Was he wrong? It doesn't matter. Taking a human life over a bottle of water is absolutely ridiculous. It's wrong under any way that you could possibly look at it. And that's why the state has gone out of their way to put this $1 bottle of water up, to put this picture up, because they want you to believe that this is what this case is about. The rest of the story. It has nothing to do with this water. It doesn't. Because if that was what it was about, this wouldn't be a complicated case. As we sit in front of you, the things that we have to talk about is we have to break down everything that we have watched in this case. And we need to break down what the state of South Carolina has presented to you. And as we break it down, we can break it down inside of 3 classifications of what they've put on the scene. They put on what they call eyewitnesses. They put on investigators. And they put on experts. You remember? Those are the 3 things that they have given us. So first, let's talk about the eyewitnesses. And the reason I want to talk about the eyewitnesses first is, remember, and I wrote down a quote that the state said, "Cameras don't lie. For 17 seconds, you could have played the camera. For 17 minutes, you could have played these cameras." If you remember, these witnesses got on the stand, they sat in front of you, and I asked them questions. They looked directly at you. They were talking about what they remembered. They were talking about their memories and how important that is. And then I started asking them questions from right there. You remember? I said, "No, I'm not trying to be rude, but I remember you talking to 911. Do you remember that?" "Yeah." "And you said something different to the 911 tape that you're saying right here today." I asked another person, "Isn't it true that we don't interview witnesses together because they can get their stories together and their brains could get something that didn't really happen?" "Yeah." "And that's on video, correct?" Cameras don't lie. "And they called 911, and in the 911 call, they said they didn't see anything, correct?" Cameras don't lie. "But don't you remember," and I asked one of the witnesses, "isn't it true that you told them something and they said that was completely impossible?" "Well, yeah." "And then they've met with you, they've talked to you, they've interviewed you and put you on the stand and you told something different." Cameras don't lie. So why are we sitting here and not watching those videos? Why didn't the state give you the 911 calls? Why didn't they give you the videos? Why didn't they give you the information? If cameras don't lie. The rest of the story. I talked to one of the investigators and officers as he took the stand. Remember, we asked him, what is important as an investigator? It's important to get the facts, it is important to get the information, it's important to get the evidence as close to the incident as possible. So we can do what? You remember the question I asked him? So we can give all the information to the jury. The rest of the story. Because what we don't want to do is subject and put our emotions in there, our personal beliefs, our subjective decisions. That's what's happened. The rest of the story. But for some reason, the state of South Carolina doesn't want to give it to you. One of the witnesses took the stand, if you remember correctly. Detective English took the stand. You remember? One of the first ones they put on. And they put the videos up on all of these screens, all this technology that the state of South Carolina has. And they put up all of it. And one of the clips they put up was of Rick Chow's statement. You remember? And they played it, and it said, my son saw, I didn't initially see my son that he had a gun, so when I looked at his hand, and then what did that officer do? He just walked away. We knew there was a second part of the video. Cameras don't lie. It would have taken how long was the quote? 17 seconds to play it. Cameras don't lie. And what was the next question from the state of South Carolina? Isn't it true he didn't tell you on that scene blank? Cameras don't lie. So we literally had to make sure you knew the rest of the story. And what did we do to tell you the rest of the story? We brought that other officer on to tell the rest of the story. And you remember, it went right together. The rest of that statement. My son saw, I didn't see it initially, my son alerted me that he had a gun. So when I'm going to go talk to his son, that's when he walked away. And then the statement kept going. Look at his hand, he actually had a handgun in his hand. The rest of the story. He got up running, then my son yelled, he's got a gun. So when I watched, there was a gun in his hand. That would be some important information for the state of South Carolina to tell you. But they needed to be about $1. They need to scare you. They need to make you afraid. They made you think the great Rick Chow, this evil human being over here, killed a man over $1. And that is disgusting, that is awful, that is abhorrent, but that's not what happened. The rest of the story. We don't want to tell you the rest of the story because if you hear it, then you get to make an intelligent decision, and we don't want you to make an intelligent decision. We don't want you to hear the 911 calls. We don't want you to watch the videos. We don't want you to hear what Rick said at that moment, at that time, without a lawyer, without anyone telling him what to say or do. We had to play those for you. The rest of the story. And as we get in there and we listen to this and we go through all of this information, it becomes incredibly important. We then had investigators take the stand. You remember the questions I asked of the investigators and why they were so important. The state of South Carolina, for you to make a decision, has come in front of you and said, put witnesses on the stand. Guns aren't that bad. 14-year-old kids have guns all the time. And they had witnesses literally with their hands on the Bible looking at you, talking about, guns are prevalent, it's not that big of a deal. That was the testimony. I didn't make that up. That was the testimony that they submitted. Do I think they believe any part of that? Not a line of that. But they have emotion. They're upset. And they want you to believe it's about a bottle of water. It's not. The rest of the story. And then there was an expert who took the stand. You remember? I asked her a very directly question. I had her sit right here. She stood in front of you as if she was Rick Chow. And I showed her what we said Mr. Belton could have been doing. And what did she say? Yeah, that's possible. The rest of the story. She described the bullet path, back to front, right to left, slightly upward. The rest of the story. We got to avoid all of that because that changes our narrative. So now we go into what they did present. And let's talk about the part of the case that we're all wondering about, the thing that everybody's there, and if it's in your gut, it should be in everybody's gut. And they spent their entire case. Their case was a day and a half, and most of it they spent it on one part. chase, the chase, the chase. They shouldn't have done it, they shouldn't have done it, they shouldn't have done it. You remember one of their witnesses, the investigator, got on the stand and I had to ask him the question, is there anything illegal about that? No, sir. But that's what they're talking about. Well, common sense. We don't want you to do it, but it's not illegal. That's an important distinction to know. This is a store. The testimony was they've owned it for 11 years. Margins are small. You've seen the wall of shame. People have shoplifted, people have stolen. Chased them. I've been stolen from. I chased the people to Georgia, flat out. It's their property. They're emotional about it. And that's why he ran after it. The question isn't, do you think it's right? The question is it legal? And then you go to the second part of it, is it legal? If it was illegal, don't you remember Andy Chow sat up there on the stand? And Mr. Scott got right in his face, and he was yelling at him, and he was going angry with him, and he was saying everything to him. But the one thing he didn't say to him is, and you have been charged with following this young man out of the store. And you are criminally liable for following this young man out of the store. Because he's not. He's not liable. He's not criminally liable. He has not been charged. And he did not do anything wrong. But when you Monday morning quarterback and come back and look at the situation and say, well, why? You know what? They could have done this. They could have done this. They could have done this. Because that's what the state's case is. Think about it. How many times did you hear throughout the course of this trial the great state of South Carolina say the following sentence? They could have done this. 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 They don't have evidence to offer, but they have fear, passion, emotion, and they want to get that out of you. They want that fear, passion, and emotion, and for you to ignore the law. We do not get to take the law the way that we want it to be. We take the law the way that it is. Let me tell you that again. We don't get to take the way that we want it to be. The solicitor can't say, well, I want it to be illegal for a shopkeeper to go out of the store. Shopkeepers should not be able to follow somebody. That's what I want. Andy, that's what I want. That's not the law. And then there's one last part that he, for some reason, has ignored. Let's say one of you, just one of you for argument's sake, are sitting back there and you say, you know what? I think they are at fault in bringing on the difficulty. It may not be legal, it may not be illegal, but I just don't like the fact that they follow him for 130 yards. I do not like the 130 yards. I do not like the 130 yards. Well, the judge is going to charge you on something on the law, and it's called withdrawal. Let me explain that concept to you. Let's say one of you start a fight. Let's say I start a fight with Mr. Scott. And let's say I go up to him and I say, I'm going to get you. I'm going to take you down. I'm going to hurt you. And I start the fight and I come at him. And I'm about to hurt him. And then all of a sudden I said, you know what? This is stupid. I don't want to do this anymore. And I turn around and I'm like, I'm over this. And Mr. Scott brings a knife and comes out. Well, according to their theory, I've got to let him stab me. According to their theory, I've got to let him hurt me, even though that I have withdrawn. Well, that is the law of withdrawal. If an individual says, if they withdraw by words or actions, their right to self-defense is back on the line. The rest of the story. And don't take my word for it, the judge is going to instruct you on the law, and that's one of the things he's going to talk about. So when we talk about the chase, when we talk about why did they run out of the store, when we talk about they shouldn't have gone out of the store, as I've told you, you legally have a right. The officer, their own witnesses told you, they legally have a right. This officer with 25 years of experience, dealt with shoplifting, dealt with this, and says, we prefer you not, common sense. But then there's a last part of that wasn't on their little pretty board, the right to withdraw. When Andy Chow testified, when he told you what happened, he said, I was following him. I was running after him. He fell. When he got up, he had this gun, and then I went this way. And as his hands were up, remember I asked him directly, the gun was still pointed at you? Yes, sir. You were looking directly at the barrel? Yes, sir. And then what did you hear? I said to my dad, he's got a gun. He's got a gun. And then what did he say his dad said? Drop it. Stop. Drop it. No. There's not more withdrawal than that. When he's yelling, stop it, Drop. No. That's a withdrawal. That's saying, look, man, you got it. You got the gun. I'm good. They love to say that everything could have stopped. He could have put the gun down. But we have to ignore that because that's not part of their story. We cannot tell that part of the story because it's not necessary. And when we tell this story, you might look at me and say, oh, Mr. Kent, that's some creative lawyering. No. That's why we played the 911 tape. And in the 911 tape you heard. That's why we played Andy Chow's interviews. Didn't hide it. What do you say? Takes only 17 seconds. What was the other quote? Better than any eyewitness ever could would have been a video. That's what the state said. Better than any eyewitness ever could. So why wouldn't you play them? Because it would have been better than any eyewitness ever could. Now let's talk about the fact, we talked about the store and the things that happen inside of the store. And there might be questions, why did you guys keep bringing these things up? If you remember, I had the officer on the stand. Great officer, great investigator, great person. But I had him on the stand, and I was talking about firearms and 14-year-olds, and he went back and forth because I don't think they wanted to admit that this is a problem. But the thing that was the most important is I asked him about suspicious behavior. Did something look weird to you when you went back? And he didn't want to admit it. But use your own common sense on that. I asked him the direct question, looking back through your investigation, as you have gone through and looked at the full file and looked at everything now, do you find it weird, odd, suspicious that a young man would go into a gas station without any money, with an empty book bag, bullet in the chamber, and then was looking like he was taking stuff off of the counter? I don't find that suspicious. I find that answer suspicious. The reason we brought this up is not to suggest I don't know what Cyrus was doing. I don't. But use your common sense and ask yourself, that does seem strange. And the reason we bring that up is that would explain why Andy, who was sitting at the front counter, looking back, is watching this and going, he's acting strange. He's acting weird. He's putting water back up, water back up, water back up. It looked weird to me. And then he came up to the counter with his hands in his hoodie, and there looked to be something heavy in there. I didn't know what it was, and so I asked him, and he did this, and it looked like there was something heavy in there. It was the gun! Did Andy know it was a gun? Absolutely not. But you can understand why Andy would have said there's something strange going on. His behavior, something in a pocket, going weird with the water, that's what was strange. So that is to explain why Andy made the unilateral decision that there was something strange going on here. And then Andy made the decision to follow him out of the store, chase him, run after him, whatever you want to call it, but he made that decision based upon a reasonable belief of what anybody would have thought something strange here. I asked the officer, again, about the suspicious behavior. That 24 hours, less than 24 hours before he came into the store, he posted this on his social media. Do you remember? I asked him about it. And not only was it this was a clip from a video in which he was pointing a gun at a screen with a laser and a flashing light on his Instagram story. You put all that together, you can explain that someone's behavior would have been a little strange. And he would have had that firearm with the light on it. It makes sense. And so that explains why Andy, and don't forget, when the officer was talking and asking questions and he went back to the back to look at that video surveillance that they keep talking about. Do you remember how many times? He's like, I had to look at it 2-3 times. I had to zoom in on it. He had the technology to see what was taken. Andy had one time. And from his vantage point, something was going on. And so he followed him out the store. He ran after the store, whatever you want to call it. The rest of the store. And then Andy testified that he threw stuff out of his pocket. You remember Mr. Scott said, you did not testify to that. I had to show 4 different times where Andy said he was throwing something out of his pockets. 4. And so he went after him. He followed him. He chased him. He's going after him the entire way. And they're right. He fell. He fell hard. And now they're saying, well, he would have naturally picked up his gun. That's why this is important. He's running. Or let's put it this way. Let's try two. One, he's running and it's in his pouch. He falls. The light goes off, but the gun stays in the pouch, I guess. Or the gun comes out, I guess. I don't know. But he picks it up. And that's what they just testified to. He picked it up. The judge is going to tell you something else about defense of others. You have the right to act on appearances. And you have the right to be wrong. He's going to tell you that. They've just told you. He was running, he fell down, and he picked up a firearm. All this stuff, all this back and forth, he 100% from the state's mouth, he picked up that firearm. You have a right to be wrong. You have a right to act on appearances. And that's what the judge is going to tell you the law is. And that's from the state. I want you to think about that again. Gets up. Medical examiner, shot, back, angle, pointed. Right to act on appearances. Rest of the story. Or take it another situation. What makes sense? Maybe the light's on the fire. And then as he's running, when he falls, that's when it comes off. We don't know. Because the burden of proof is on the state to prove what happened in that situation. And they've just admitted the one thing we know for a fact is he picked up the firearm. That's from them, not from me. That was their admission. And then as he picks up the firearm, then we have to go with Andy's testimony. And he's right. If you don't believe what Andy says, if you think Andy is 100% a liar, you can stop right now. Andy's lying. He made it up. This is completely not true. The gun was never pointed at him. He never saw this silver barrel that he only would have seen after he saw Discovery. He never saw it. And then let's take that one step further. Not only that you must believe that he is a liar, you must believe that Rick Chow is the most creative, smartest person in the history of the world. He is clairvoyant, if you will. Let's give him an Oscar. Rick Chow was able to decide, you know what, I want to kill this boy. I need to figure out when he's going to come into the store, when he's going to have a gun, when it's going to be in his pouch. I need to make sure that Andy sees it. And then I need to make sure Andy follows him for the direction. So I need to make sure Andy calls 911 and says exactly what I want him to say. I need to make sure Andy says the exact thing that I'm going to say at the exact time. Because that's what it would be necessary to believe the state of South Carolina's case today. That Rick Chow set all this up in motion to execute a shoplifter. The people he decides, needs, has to help him make a living. It doesn't make any sense. And if we take this one step further from the state's theory, Rick Chow is so pissed off, so damn angry about this shoplifter, hates him so much that he executes him. Why not shoot him when he gets out of the store? Gun's already on his hip. Why not walk out of the store? Shoplifter, $1, he stole, shot. Shoplifter, 10 yards, shot. Shoplifter, 20 yards, shot. 30, 40, 50, 60, 70, 80, 90, 100, 110. Why wait 130? Unless something changed. What changed was somebody pulling a gun and pointing it directly at his son. That's what changed. If he wanted to execute Cyrus, he could have done it right outside of that store. But we have to ignore that because that would be part of the rest of the story. Use your common sense and listen to the evidence, but listen to the witnesses and listen to what they have told you. Murder, as the state has told you, is the intentional killing of another human being with malice aforethought, without self-defense. We have just showed you self-defense and defense of others. The state has melded a little bit of those theories together, but you need to make sure that you understand. One, without fault and bringing on the difficulty. Again, I've explained to you that you have a legal right to follow somebody. Whether they like what the law is, that's what it is. And as you're going through that, then you have to talk about imminent danger. And this is from the eyes of Andy. And they're trying to mix the two of the things together, but it's under the eyes of Andy at this point. As Andy, does he have a fear of imminent danger? Was a gun pointed at Andy? Would Andy, who had withdrawn from the conflict, you got it, I'm over this, no. Would Andy have had a right to point the firearm and save his own life? Reasonable person. A reasonable person in the same situation, what would they have done? And we can take that two ways if we want to argue the state's theory. Way one, Andy, gun pointed at you. Would he have had a right, as he rescinds, remember that knife in the back situation? Andy would have had a right to fire to save his own life. But more importantly, the reasonable person's situation, Rick Chow would have had a right, and did have a right, to save his son. The strongest evidence that was given in entire this case is when the officer got on the stand and I asked him that question. And I said, have you ever fired your firearm? No. Have you had a firearm pointed at you? Yes. I didn't fire. What if someone was pointed at your loved one? Yeah. I asked that same officer the situation when officers are chasing somebody and you chase them incorrectly. Remember we asked him that question. You chase somebody incorrectly, what happens? We chase them incorrectly, it does happen. And what would happen if that individual pointed a firearm at you? Remember the example he gave? If someone pointed a firearm as I'm chasing them incorrectly, well, I would tell, and they turned around and pointed a firearm at me, I would tell them, stop, drop it. And if they did not drop it, I would fire. It sounds eerily familiar to this case. And that's some of the rest of the story that the state of South Carolina, for some reason, has chosen not to tell us today. And then we go, duty to retreat, or can you retreat? As a person is pointing a firearm at you and you're pulling backwards and someone is saying, stop, no, don't. That's what duty to retreat is. No one turns and runs. The judge is going to tell you, as I mentioned, if we're talking about self-defense, and I've said it several times, you have a right to act on appearances, and you have a right to be wrong. So as we sit here, and we're in Rick Chow's position, we're wondering what Rick Chow is doing. As we've heard this testimony, Rick Chow sees a gun pointed at his son. His son says, as you heard, I was afraid, I was terrified. He's got a gun, he's got a gun. So Rick Chow in that situation stands in the place of his son. This case is not about a dollar. This case is not about a shoplifter. This case is about a father who sees a gun pointed at his son and had to make a decision. I hate it. I do. I hate that a young man lost his life. I disagree with the state's theory on it's not that big of a deal that kids are going around with guns. I hate it. It is a problem. And it is a problem in this case. I hate that we have sat here and tried to make this about something that's not. I've listened to the state of South Carolina's opening statement talk about Cyrus's age, his future, and I understand all of that. I do. The one thing that does not know Cyrus's age is that gun. The gun doesn't know how old he is. And when a gun is pointed at somebody, you have an option. As we sit here and talk about this case and how important the details are, that if you step back and look at something one way, it's completely different. And as you get closer and you look at it more and you look at all of the details, you'll never see it differently again. And so what I'm asking you to do is focus on the details. I wear this suit all the time in trials. People say, oh, you always dress so flashy, but you're not flashy. I wear this suit all the time because it reminds me that details are the most important thing that can happen. It actually has my name and the pinstripes in it, because when you look at it, after realizing it's not just a pinstripe suit, it actually has my name just right down the middle. And I look at it and it reminds me in cases that if you don't take your step back and look at things in full detail, you will miss it, like the state of South Carolina has, and they want you to miss it. We have to focus on important matters. We have to see the full story. You have to ask yourself the question, why don't they want me to know the full story? And then finally, for the state's case to make any sense whatsoever, we have to go back to our withdrawal situation. For the state's case to make any sense whatsoever, you must be comfortable with their theory in that Andy Chow is in the store. Andy Chow runs out of that store. Andy Chow runs out of that store after Cyrus. And as he's running out after the person he thinks is shoplifted, Cyrus still points the fire. Andy still has his hands up. His dad is still watching, and his dad says, no, I'm not going to do anything. And Cyrus shoots and kills his son. The state wants us to believe that that's legal, and that's okay. That storekeeper should let people take stuff out of their store, and if you follow them and you get killed, it's okay. It's not. Now, you know the rest of the story.
Anything in reply to the state?
Yes, Your Honor, of course, the note is fine. Move a couple things around.
Yes, sir.
Thank you. Please go ahead, Johnson.
Yes, sir.
Johnson. Mr. Kent spoke to you guys, ladies and gentlemen of the jury, for a moment or two. And he talked about Paul Harvey and the rest of the story. Sounds a lot to me like this was the rest of Mr. Kent's story. Because many of the things that he said were things that he said, but the actual eyewitnesses never said. It reminds me of when I was a kid, a couple of years maybe before Mr. Kent, but a whole lot of years after Mr. McCullough and Mr. Swirling. We used to, as kids, go down to Augusta, Georgia. My grandmother was from a small town called Trenton, South Carolina. It's in Edgefield County. And way before I was born, probably when I was still a twinkle in my parents' eye, she moved down there because there were just better opportunities to work. And so as I'm growing up in the early 70s, early 80s, my folks would drop me and my brother off down there, and we'd hang out with my grandmother for a week. And back then, when you went to your grandmother's house, you couldn't stay inside and play video games all day because they didn't have them. So we had to go outside. We had to find ways to busy ourselves. We had to do things outside so we didn't break anything inside and get in trouble. So what we end up doing is my brother and I would go outside and we'd start throwing the football around for a little while. We'd toss the baseball around for a little while. Then we would start running around her house because my brother was older, so I tried to catch him. So we try to run around and see if I got any faster than he. At some point in time after lunch, we would make our way to this makeshift barber shop that my grandfather had built on the side of the house. And we'd sit down and we'd listen to the old man playing checkers, trying to pick up on some words we probably shouldn't have been hearing. We'd hear him slapping the checkers on the board saying, "King me," and all that kind of stuff. And we'd be learning some old man stories as kids. It was fun. We'd sneak into a little side of the barber shop and try to get his red man shoe. And the joke was we'd try to put a little piece in our mouth and try to hold it in there as long as you could before it burned a hole in your mouth. Or we try to hold it in there and try to see who could hold it the longest before you started gagging. This mischievous stuff that kids do. That's what we did. But at the end of the day, every evening, my brother and I would end up on the front porch. And my grandmother had a set of rocking chairs out there. And we would sit in those rocking chairs and start playing what I call rocking chair games. The first game, we'd sit down and then we'd try to see who could rock the fastest. I'm sure some of y'all have done this. Then we try to see who could rock the fastest and the farthest with your legs in the air. It's good ab work if you ever need to do it. We're trying to go back and forth and see how fast you could go with your legs in the air. And inevitably, the last thing that my brother Chris and I would do, we'd sit down and we'd rock the chair as far back as you could go without it falling over. And we'd do that. And we did that over and over and over. One evening, my grandmother came outside and she saw us standing those rocking chairs up on edge. And we knew we were in trouble. Again, this is the 70s, early 80s. This is the day of knockouts, not timeouts. We knew we were about to get in trouble. But my grandmother said something to me that stuck with me and it still rings in my head today. She said, the funny thing about rocking chairs is that they'll keep you busy, but in the end, they don't get you anywhere. The funny thing about rocking chairs is that they keep you busy, but in the end, they don't get you anywhere. Ladies and gentlemen of the jury, Mr. Kent, Mr. Swirling, Mr. McCullough, and that team over there has kept you busy with all of this stuff. But at the end of the day, the question still remains, what is the value of a human life? They have kept you busy with these insinuations that Cyrus was some young thug, some thug in training, running around Columbia, their words, with a loaded pistol, an empty backpack, and no money. Their words. They have kept you busy with this insinuation that this case has to be about and is only about, and is mostly about, a 14-year-old carrying a gun. We keep talking about why do 14-year-olds have guns? Why do children carry guns? And folks, let's be abundantly clear. Cyrus should not have had a gun. Period. No question. Nobody at the state stable has suggested that he should have. But let's put that aside for a second as we talk about what this case is really about, because he shouldn't have had a gun. No question. Question, are we still having this conversation if Cyrus is 24 years old, if he's 20 years old, if he's 34 years old, 44 years old? Are we having this conversation? Somebody wrongfully accused of stealing, chased out of the store after they tried to de-escalate everything that they could, running, falling down, running out of your chute, tripping, dropping phones, running farther, falling, busting your shin, gun spills out, you're still running. And according to the testimony that you heard from this chair, grown man, Andy Chow, state championship swimmer, 185 pounds, 200 pounds, about 85 pounds more than Cyrus, was right on top of him when he fell. And Dad was close by, in arm's distance. That's what the testimony was, not all this stuff. He was right on top of him. Question, as you listen to the elements of self-defense, not bringing on the difficulty, who would have had a claim of self-defense in this case? Cyrus? Being chased by two men armed with a gun on top of you after you've run 130 yards? Folks, I submit to you, as I'm walking from that tip back here, you get to the end of this corner, that's 20 yards, 19 yards. Times 5 plus 30 more yards. That's how far he was chased. So who would have had a self-defense claim? So I'm suggesting to you that they keep insinuating these things, saying these things, because they don't want you to think about it. Again, I mentioned to you this to you multiple times. When you parked your cars, you didn't leave your common sense in the parking lot. Take it with you. Think about these things. Don't let them sway you with all of this mess and all this other stuff that takes us off of what the real issue in this case is. Don't let them do it. The defense kept weaving this narrative, again, that Cyrus is some young thug walking around the streets of Columbia, again with a loaded pistol, no money, and an empty backpack. I submit to you that, folks, if Cyrus was this thug that they keep telling you that he was, by showing you pictures and trying to get you thinking in that direction, we never would have gotten 130 yards down the road. He would have held court right at 7441 Park Lane Road. Cyrus would have been the judge, the jury, and the presenter of the sentence right there in that spot, if he was the thug that table wants you to believe that he was. But instead, what were his actions? Folks, he ran. He ran like a child. He ran from the adult. Let's think about who acted like the thug, the gangster. The person who chased him down the street, or the person who ran while he had a gun hidden. He ran out of his chute. How do we know that to be true? Because we see it on camera. Shoe flies up in the air, and he keeps running. Doesn't stop, turn around, oh, I dropped my shoe, let me get that, because I'm gonna get in trouble if I go home with one shoe. He didn't do that. How afraid do you have to be to run out of your shoe and not turn around to pick it up? Ponder on that for a minute. He ran further, phones fell out. They keep coming to you with this mess that, oh, he threw his cell phones out. What sense does that make? Did you leave your common sense in the parking lot, or did you bring it with you? How afraid do you have to be to drop 2 cell phones and keep running? Again, let's be very logical about this for a minute. 2 cell phones. We know how expensive they are. One cell phone belongs to you, and the other belongs to your mother. Do you mean to tell me that you are going to go home that day with one shoe and tell your mother, Mama, I lost my cell phone and yours too, and I didn't turn around to get it? You want that smoke? Do you really want to get what you would get if you lost 2 cell phones from your mother? But you know why he didn't turn around? Because he was scared. Because that man, armed with a .45 caliber pistol, and his son were chasing him for no reason down a road in South Carolina. Chasing him. Didn't turn around. Kept running further. Fell again. Hard. Dropped the backpack. And by the way, since they want to keep saying it was empty, actually had some personal effects in it. There was an address in the backpack. Really? Fell. Dropped the backpack. Didn't stop and say, oh, stop guys. Let me go get my backpack. Let me go get the phones. Let me go get the shoe. Kept running away from them. Is that a thug? That's a kid who was scared of 2 grown men, running as fast as he could, as far as he could, trying to get home. But they wouldn't allow it. They would not. For some reason, they could not allow it. And then, at some point, as he fell, hit the ground, that gun comes out, that tac light comes out. Now, I'll suggest to you As Mr. Kent talked, he keeps saying, well, he was picking up the gun and he was pointing the gun, all that kind of stuff. Stop, just stop. Because what we say is not evidence. I told you before, the evidence is what comes from this witness jury. There were 4 eyewitnesses who were not named Chow. Which one of them ever said they saw Cyrus Carmack-Belton point a gun? Which one? Which one? No. 4 of them. 3 different vantage points. Lori Carson, Kennedy Carson, mom and daughter. They told you they watched and they saw a straight line of what happened. Cyrus ran, fell, hit the ground, got up running, and that's when he was shot. Asked multiple times, well, did he turn at them? Did he point at them? Did he do anything? No. We never saw anything in Cyrus's hands. 2 witnesses, mom and daughter, vantage point at the front of the store. Didn't see any of that. Any of that. Devontae Bryant, driving, white Honda, threw on brakes so he wouldn't run over anybody as they ran in front chasing Cyrus. Asked as he rode by, did you see him point anything? Cyrus Carmack-Belton point, stop and point. No, he didn't. He didn't have anything in his hands. The book bag fell. He was flat. He fell hard. His hands were on the ground. He got up trying to run, and that's when he started stumbling again and got shot. Again, trajectory. Here, upwards, to the left, making perfect sense that he's running away. Not pointing. Not pointing, like the defense wants you to believe. Remember the multiple times they tried to see with Dr. Durso, well, was he doing this and was he snaking and popping and locking? No, none of that was ever said. He was running, and when they tried to do that, he said, no, it's more consistent with the shooter being directly behind him. Folks, if he was turned in the direction that they want to believe, his spine would have been severed by that bullet. Common sense. You didn't leave your common sense in the parking lot when you parked today. You brought it with you. That again is why we went through that process. Some of you may think it was painstaking last week to sit you as jurors, because we wanted you to take the facts of this case. Not Paul Harvey, not Steve Harvey, not some other Harvey, but the facts of this case that came from this witness chair. Not some stuff that's speculated or what we can kind of come up here and start trying to come up with about moonwalking backwards and all this kind of stuff. None of that. The evidence that came from this chair. Did you hear that? Another witness. Jasmine Broadwater. Another vantage point. They're running directly to her. Did she say she ever saw a gun in Cyrus's hands? No. Did she ever say she saw Cyrus point? No. Never. Nobody with the last name that's not Chow says that ever happened. And interestingly enough, you saw in the video, after the shooting took place, who was walking around? Richo. The officer had to tell him multiple times, stand still, don't touch evidence. I'm gonna charge you with obstruction, you keep messing around there. Move the gun, by the way. He and his family went to the store, came back, had plenty of time to talk about what they were gonna say. Plenty. But at the end of the day, when Andy sat up here, there was nobody to protect him from cross-examination. Nobody to protect him. There was conversation about a barrel. Andy says, I saw a silver barrel. Folks, I submit to you, there is a gun lock on here. This is not the condition of the gun. You'll see it on that video. The condition of the gun was this. That's a black barrel, right? Ladies and gentlemen of the jury, we talk about credibility and believability. Well, we'll get to that in a minute. One other thing that the esteemed table said is that Cyrus Carmack-Belton, again, wandering the streets with a loaded pistol, empty book bag, no money. Now, I'll take this on myself because at the end of the day, I'm the boss. And I'm the person who at the end of the day gets the opportunity to say, hey, we need to bring this witness or that witness. So y'all blame me for this one. This is my fault. I will say this, it's my fault. Maybe we should have brought in another expert. Maybe a 10-year-old or a 12-year-old or a 13-year-old who can talk to us about the intricacies of cell phones. My gosh, maybe they could tell you that if you hit the right click button on an app.
Yes, Lily first. Sure.
So maybe we should have had an expert to talk about apps on phones and the fact that in 2026, even back in 2023, you did not have to have cash in order to buy stuff. You can pay on your phone. Maybe that should be an expert that we call next time, since they made such a big stink about those things. Folks, Andy was an interesting person on the stand. And I'm sure that it's tough to have to sit in that situation and recall what was said and what wasn't said and what you thought about in those moments. But it was interesting to me that under direct examination, that testimony flowed. It was quick. Everything that he said was perfect, just came out like water. But then on cross-examination, and y'all had a chance to watch from your vantage point, that's the word of the week, vantage point. Every time he was asked a question under cross-examination that wasn't pleasant, that actually required some type of thought process that may not go exactly how he rehearsed his testimony, eyes. To the point to where he said, well, my counsel said I couldn't. We don't want to know what your counsel told you. But every time a hard question came, his eyes went from here to there. Folks, I was taught a long time ago, when you lie, you got to remember what you said, right? And if you lie about the small things, then you can't be trusted with the big things, to tell the truth about the big things. So think about that for a minute, because when we talked to Andy, there was a back and forth about simple stuff, like through versus dropped, right? Like pulled versus pointed, which again, no witnesses not named Chow ever said the word pointed. Like chase versus follow. Why are we having conversations about chase versus follow when you saw how fast they were going after him? Folks, I may not be the sharpest tool in the shed, but to me, running after requires you to be going after something for a purpose. Example, there's a kid, ice cream truck passes by the house, ding, 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 ding. You miss it. You go out the house and you run after the ice cream truck. Why? Because you want to catch it so you can get some ice cream. Simple. Or sitting, you wake up a little bit late for school and you hear the bus go by. You're missing the bus. You run after the bus. Why? So you can catch the bus and get on and get to school. Or maybe more recently, you're flying from Columbia to North Dakota. And there's a flight that first leg takes you to Charlotte, second leg takes you to Minneapolis. You get to Concourse A, your flight takes off in 28 minutes. What you gonna do? You're gonna run to Concourse C to catch the flight. Why? Because you don't want it to leak. You run with the purpose to catch. Folks, I ran after my wife for 2 years, and I caught her. But do you think when I caught her, I said, hey, I want to give you directions about how to get to that dude so he can tell somebody else about something. Come on, folks. When you parked your cars, you didn't leave your common sense. They ran to catch. At the end of the day, what happened here is simple, and they don't want to admit it because it hurts. They ran after Cyrus emotionally. They were irritated. They were mad for whatever reason. They ran after him. They caught him. They caught up to him because he fell multiple times. They wanted to shake him down and get that bottle of water and then figure out what to do with the police later. That's why they ran. That's the simple truth. That's the simple truth. That gun spilled out, and then that man made a rash decision. He overreacted. Andy saw the gun. He said gun, and he shot him. There wasn't all this time to back up. No witnesses even say that he even backed up. They said they were advancing the entire time. Folks, don't let the defense rewrite the facts, because the things they talked about didn't happen that way. They didn't happen that way. For over an hour, Andy sat on that stand, and he said a lot of things. He said a lot of things. But did you ever hear the 2 words? I'm sorry. I'm sorry that I wrongfully accused this kid of stealing and chased him down the road. You know why? You didn't hear that? Because he's not. This is about product over people. This is about inventory. This is not about a person's life. Mr. Kent spoke about withdrawal. And he keeps trying to suggest that Andy Chow withdrew by doing this and coming backwards all this way and saying, hey, stop, hey, Dad, you gotta go. Nobody testifies that happened who doesn't have the last name of Chow. 4 people who don't know one another, who had to be subpoenaed to come to this court, spoke to you, and they never said that it happened, because it didn't happen. He did not withdraw. They kept going forward. They kept going forward. And ultimately, this gun was never pointed. But folks, I suggest to you, even if it was pointed, he was running in the opposite direction. Opposite direction. That's what the evidence shows by the way he was shot. It was in the opposite direction, trying to get away. I'll say this. It's offensive to hear the defense keep trying to characterize Cyrus as this young thug. But it's equally offensive to then try to characterize Andy Chow as Mr. Rogers. Excuse me, Rick Chow, the defendant in this case, is Mr. Rogers. You know, the man who chased a kid down, shot him in the back. And then they want to say, well, he was trying to help, clean vomit out of his mouth to resuscitate him. Folks, that's offensive. Because the last face that this scared child saw as he ran away was that man peering over him. Peering over him. And none of this happens if they stay their behinds in the store and use that intricate camera system that picked up on every angle. Could see everything from what he wore, the type of shoes that he wore, the direction he went, everything. A couple seconds is all it would have taken, just like it did in the store, to say, hey, you know what, we were wrong. But they didn't do that because they were overcome with something. Maybe it was meanness. Maybe it was malice. Maybe there's some nefarious intent in their heart. a reason for them to chase him and shoot him in the back and end his life. But again, never the two words that matter most, and I'm sorry or I made a mistake, however, none of them, because they're not. I talked to you about a poem by Omar Khayyam called The Rubra, and I told you that I would link it all together. The moving finger writes, and having writ moves on, nor all your piety nor wit shall lure it back to cancel half a line, nor all your tears wipe out a word. Folks, that's a poem about time and how you can't erase what's been done. You can't go back and change what's been done. With all your piety nor wit, no matter how many degrees you got, how many doctorates you got, when you do something, it's there, it's done, and you can't reverse time. You may try, you may get up here and get on the stand and try to think your way through it and reason your way through it. But at the end of the day, what they did was murder. So in a more literal sense, eventually we're going to be asking that your moving hand come back and write these words. Because Rick Chow is guilty of the murder of 14-year-old Cyrus Carmack-Belton. Now, folks, you're going to have a chance to deliberate in a moment. And as you deliberate, you will apply the facts of this case to the law that the judge is going to give you in a couple of moments. And as you do that, I'm asking, Dale Scott is asking, Stephanie Taylor and Weston Lee, for all of us are asking that you return a verdict of guilty in this case. I'm just looking to make sure that I covered everything that Mr. Kent covered. I ask you to think one last thing, and I'm out of your face. We all know there are 50 states in the United States of America. But I think I've learned sitting in this trial that there are actually 51. There's the state of denial. The state of denial is where that man lives because he's denying that what he did was wrong. He's denying that he chased and killed that young child, Cyrus Carmack-Belton, who never pointed a gun at him. The witnesses tell you so. Not his son, who's got every motive, every reason to twist it around in order to protect his father. Denial that you, the jury, believe or will believe that what he did was wrong. Denial that at the end of the day, he believed that a human life was not more than that. Folks, it's for these reasons that the state of South Carolina is asking you to return a verdict of guilty, because Chai Key Rick Chow is guilty of murdering Cyrus Carmack-Belton. Thank you for your time.
Thanks, Mr.
Take care.
Madam Floor Lady, ladies and gentlemen of the jury, you've heard the evidence and the arguments of both parties. I'm now going to explain the law which you will apply in this case. Well, maybe I'll do that in a moment.
Quiet, we're still in session.
charges that I'm going to read to you will not be sent back to the jury room, so it's important that you listen carefully to the instructions. If you have any questions during your deliberation, I can bring you back out and explain the law to you again if you have specific questions about the law. Now, you and I have specific duties to perform, like we discussed from the outset. As the trial judge, it is my responsibility to preside over the trial. It's your responsibility to consider the testimony which has been presented from the witness stand and the exhibits introduced. I have the duty to charge the law applicable in this case. As presiding judge, I am the sole judge of the law, and it's your duty as jurors to accept and apply the law as I now state it to you. If you already have any idea as to what the law is or what the law ought to be, and it does not agree with what I tell you, the law is, you must abandon your idea because you are sworn to accept the law and apply the law exactly as I stated to you. Your duty is to determine the facts. In every case, the jury is the sole and exclusive judge of the facts. A trial judge cannot suggest, state, comment on, or make any statement to a trial jury about the facts in the case. Since you are the sole judge of the facts, you are not to infer from what I have said during the progress of this trial in ruling upon the admissibility of evidence or otherwise, or anything that I say now during the course of this instruction to you, that I have any opinion about the facts in the case. The law does not allow me to have an opinion about the facts. This is a matter solely for you to determine. As jurors, it is your duty to determine the effect, value, and weight of the evidence presented during the trial. The indictment charges the defendant with murder. The fact that the defendant was arrested, charged, and indicted is not evidence and cannot be considered by you as evidence of guilt, nor does it create any presumption or inference of guilt at all. This indictment is simply the formal written instrument which contains the charge made against the defendant. It is the formal document by which this case is brought into this court and gives this court jurisdiction. The defendant has pled not guilty to the indictment, and that plea puts the burden on the state to prove the defendant guilty beyond reasonable doubt. A person charged with committing a criminal offense in South Carolina is never required to prove himself innocent. I charge you that it is a guiding rule of law that the defendant in a criminal trial, no matter how serious the charge, is always presumed innocent of the crime for which the indictment was issued unless guilt is proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies the defendant throughout the trial until you reach a verdict of guilt based on the evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is like a robe of righteousness placed about the shoulders of the defendant, which remains with the defendant until it has been stripped from the defendant by evidence satisfying you of the defendant's guilt beyond a reasonable doubt. The presumption of innocence is not mere legal theory. It is not just a legal phrase. It is a real and substantial right to which every defendant is entitled unless you, the jury, are satisfied from the evidence of the defendant's guilt beyond a reasonable doubt. What is reasonable doubt in the law? A reasonable doubt is the kind of doubt that would cause a reasonable person to hesitate to act. The state has the burden of establishing every fact necessary to prove the defendant guilty beyond a reasonable doubt. The law presumes every person charged with a crime to be innocent, and the burden of establishing guilt is placed solely on the state. The defendant is not required to prove his innocence. Some of you may have served as jurors in civil cases where you were told it's only necessary to prove that a fact is more likely true than not true, such as by the greater weight or preponderance of the evidence. Other civil cases use the clear and convincing standard. In those cases, it's necessary to prove that a fact is highly probable. But this is a criminal case, and the state's proof must be more powerful than those burdens of proof. In criminal cases, the state's proof must be beyond a reasonable doubt. Proof beyond reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. The defendant is not required to prove his innocence. If, on the other hand, you think there's a real possibility the defendant is not guilty, you must give the defendant the benefit of every reasonable doubt and find him not guilty. Necessarily, During your deliberations, you must determine the credibility of witnesses who have testified. Credibility simply means believability. It is your duty as jurors to analyze and evaluate the evidence and determine which evidence convinces you of its truth. In determining the believability of witnesses who have testified in the case, you may believe one witness over several witnesses or several witnesses over one witness. You may believe part of the testimony of a witness and reject the remaining part of the testimony of that same witness. You may believe the testimony of a witness in its entirety or reject the testimony of the witness in its entirety. You may consider whether any witness has exhibited to you any interest, bias, prejudice, or other motive in the case. You may also consider the appearance and manner of a witness while on the witness stand. There's been evidence presented that witnesses have made prior statements which are not consistent with the witness's present testimony. You may use this evidence to decide whether to believe the witness. You may also use the evidence of the earlier contradictory statements to determine the truth of those statements. It's up to you to decide whether to believe the earlier statements or the testimony given at trial. If a witness is shown to have knowingly testified untruthfully concerning any material matter, you may consider this in determining whether to trust the witness's testimony as to other matters. You may reject all testimony of that witness or give all or part of the testimony the way you think it deserves. In order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt. Criminal intent is always a matter that must be determined by the jury from the circumstances existing at that time. There is no way to prove intent to a mathematical certainty. There is no way medical science can dissect a person's brain and determine what the person had in mind. So the law says that criminal intent may be inferred from the circumstances showed to have existed. This is how you make a determination of whether or not the element requiring intent was present. It is not necessary to establish intent by direct and positive evidence, but intent may be established by inference in the same way as any other fact, taking into consideration the acts of the parties and all the facts and circumstances of the case. Criminal intent is a mental state of conscious wrongdoing. You must determine what the defendant intended to do based on the circumstances existing at that time. Criminal intent can arise from action or a failure to act. It may arise from negligence, recklessness, or an indifference to duty, or to consequences that are considered by the law to be the equivalent of criminal intent. There are two types of evidence which are generally presented during a trial: direct evidence and circumstantial evidence. Direct evidence directly proves the existence of a fact and does not require deduction. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of a fact. Crimes may be proven by circumstantial evidence. The law makes no distinction between the weight or value to be given to either direct or circumstantial evidence. However, to the extent the state relies on circumstantial evidence, the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray the defendant's behavior as suspicious, the proof has failed. The state has the burden of proving the defendant guilty beyond reasonable doubt. This burden rests with the state, regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. As I mentioned to you during the trial, the rules of evidence ordinarily do not permit witnesses to testify to opinions or conclusions. An exception to this rule exists for witnesses we call expert witness, a witness who by education and experience has become an expert in some art, science, profession, or calling, may state an opinion as to relevant and material matters in which the witness claims to be an expert, and may also state the reasons for the opinion. You should consider any expert opinion received in evidence in this case, and like any other evidence, give it the weight you think it deserves. If you decide that the opinion of an expert witness is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of other witnesses simply because the witness is an expert. Further, you're not required to accept an expert's opinion even though it is not contradicted. I instruct and emphasize to you that the fact that the defendant did not testify is not a factor to be considered by you in any way in your deliberation and in your consideration on the question of the guilt or the innocence of the defendant. It must not be considered by you in any manner whatsoever. I repeat, under your oath, you are to draw no conclusion whatsoever from the fact that the defendant did not testify. The fact that the defendant did not testify should not even be discussed in the jury room. The burden of proof, as I have stated to you, is on the state. The defendant is not required to prove his innocence. The burden of proof remains on the state to prove guilt beyond a reasonable doubt as to the charge against the defendant. The defendant is charged with one count of murder. The state must prove beyond reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exist for any particular time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the evil intent and the act. Malice aforethought may be expressed or inferred. These terms express and infer do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is either by direct evidence or by inference from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when a person prepared beforehand to do the act which was later accomplished. For example, lying in wait for a person or of any other act of preparation going to show that the deed was within the defendant's mind would be expressed malice. Malice may be inferred from conduct showing a total disregard for human life. If facts are proven beyond reasonable doubt sufficient to raise an inference of malice to your satisfaction, this inference would simply be an evidentiary fact to be considered by you along with the other evidence in the case, and you may give it the weight you decide it should receive. The defendant has asserted defense of others as a defense to his prosecution. Under the law of self-defense, the defendant may take another's life in defense of others. The right to intervene to protect another person is subject to the same rights and limitations as the right of self-defense. The defendant may take the life of a person who assaults a friend, relative, or bystander if that friend, relative, or bystander would have had the right of self-defense. Defense of others is a complete defense, and if it is established, you must find the defendant not guilty. The state has the burden of disproving defense of others by proof beyond a reasonable doubt, and the burden is carried by disproving any one of the four elements by proof beyond a reasonable doubt. If you have a reasonable doubt of the defendant's guilt after considering all of the evidence, including the evidence of defense of others, then you must find the defendant not guilty. On the other hand, if you have no reasonable doubt of the defendant's guilt after considering all the evidence, including the evidence of defense of others, then you must find the defendant guilty. The following elements are required to establish self-defense, and in this case, defense of others. First, to show that the person being defended had the right to self-defense, it must first be shown that the person being defended and the defendant were both without fault in bringing on the difficulty. If the conduct of the person defended or the defendant was the type which was reasonably calculated to and did provoke a deadly assault, the person would be at fault in bringing on the difficulty and would not have the right of self-defense. Therefore, the defendant would not have the right to use deadly force in defending that person. One's right to self-defense or defense of others is restored after a withdrawal from the initial difficulty with the victim if that withdrawal is communicated to the victim by word or act. Withdrawal from a conflict must be effectively communicated to the victim by word or act to restore the right to use self-defense or defense of others. An accused who provokes or initiates an assault cannot claim self-defense or defense of others unless the person defended both withdraws from the conflict and communicates his withdrawal by word or act to his adversary. Second, the defense of another person is excusable if the defendant had reasonable grounds to believe and in good faith did believe that the person being defended was in imminent danger of death or serious bodily harm from the victim. In deciding whether the person defended actually was or that the defendant actually believed the person was in imminent danger of death or serious bodily injury, you should consider all the facts and circumstances surrounding the crime, including the physical condition and characteristics of the parties. The defendant does not have to show that the person defended was actually in danger. It is enough if the defendant believed the person was in imminent danger. The defendant has the right to act on appearances even though the defendant's beliefs may have been mistaken. The third element of self-defense requires the defendant to show that under the circumstances as they appeared to the defendant believed the person defended was in danger, and that a reasonably prudent person of ordinary firmness and courage would have had the same belief under the same circumstances. It is for you, the jury, to decide whether the defendant's fear of immediate danger or of death or serious bodily injury to the person defended was reasonable and would have been felt by an ordinary person in the same situation. The defendant does not have to wait until the victim inflicts harm on the person defended. The defendant has the right to act under the law of self-defense of others, to prevent the victim from inflicting harm on the person defended. The final element necessary in order to be entitled to defend another requires that the person defended have had no other probable way to avoid the danger of death or serious bodily injury than to act as the person defended did in this particular instance. Where the person being defended had no duty to retreat, the defendant likewise would have no duty to retreat. The defendant had no duty to retreat if by doing so the danger to the person defended of being killed or suffering serious bodily injury would increase. When considering defense of others, the relative sizes, ages, and weights of the parties may be considered in deciding the apparent or actual need for force in defense of others and the amount of force needed. A person cannot be required to make an exact calculation as to the degree or amount of force which may be needed to avoid death or serious bodily harm. Therefore, in defense of others, the defendant has the right to use the force needed to avoid death or serious bodily harm to the person defended. The force used in defense of others does not have to be limited to the degree or amount of force used by the victim. The defendant has the right to use so much force as appeared to be necessary for complete protection of the person defended, and which a person of ordinary reason and firmness would have believed to be needed to prevent death or serious bodily harm to the person defended. Where a person inflicts an injury or death on another person, you must be convinced beyond reasonable doubt that the defendant's actions were the proximate cause of the victim's injuries or death. The proximate cause is the direct cause. It is that immediate cause. It is the efficient cause. It is that cause without which the injury to the victim would not have resulted. There must be a chain of causation from the defendant's actions until the time of the victim's injuries or death. Proximate cause does not necessarily mean that it occurred immediately prior to the injury or death. There may be more than one proximate cause. The acts of two or more persons may combine together to be a proximate cause of the injury or death of a person. The defendant's act may be regarded as the proximate cause if it is a contributing cause of the injury or death of the victim. The fact that other causes also contribute to the injury or death of the victim does not relieve the defendant from responsibility. The defendant's act need not be the sole cause of the injury or death, but must be a proximate cause contributing to the injury or death of the victim. Negligence on the part of someone else would not relieve the defendant from criminal responsibility if the actions of the defendant were the proximate cause of the victim's injury or death. Ladies and gentlemen, I have declared the law to you through these instructions to help guide you to a verdict. Whether some of these instructions apply depends on what you find to be the facts. The fact that I have instructed you on various subjects in this case should not be taken as indicating an opinion of this court as to what you should find to be the facts or as to what your verdict should be. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree. Your verdict must be unanimous. All 12 of you must agree on the verdict. The verdict cannot be based on sympathy, passion, prejudice, emotion, or any other consideration not in evidence in the case. Disagreements may arise during deliberations and your debates may become spirited. I urge you to be courteous and to one another and respectful of your fellow jurors' perspective as you work toward a verdict. Remember, at all times, you are not partisans favoring one party over another. You are the judges of the facts. Your sole interest is to determine whether the state has proven the defendant's guilt to the charges beyond a reasonable doubt from the evidence presented to you in this case. Again, ladies and gentlemen, your verdict must be unanimous. Madam Forelady, when the jury agrees on the verdict, you will fill out the verdict form, which I have here. It is very self-explanatory. It will go back with the evidence. After you've reached the verdict, Madam Forelady will fill out the verdict form and sign. Then knock on the jury room door and inform the bailiff you have reached the verdict. At that time, we'll receive you back in the courtroom. We'll ask you to return to the jury room, but not begin deliberations until you're told by the clerk or the bailiff to do so. There are a few more matters of law that I need to discuss with the lawyer before you begin your deliberations. All right, so I'm going to ask you to help back. I believe your lunch is already here. So y'all can get started with that. We'll be with you very shortly. I'm going to ask the alternates to please stay with us. Exception to the charge from state.
None, Your Honor.
Any exception from the defendant?
Your Honor.
Judge, can you indulge us one moment? I need to find something. Is all right? Give me a minute.
All right, while y'all are working on that, our alternates, you are now excused. You do have lunch back there, but thank you for being here. Again, like I said from the outset, we can't do our job without folks being willing to show up. This is very, as you can see in this case, a very important job. So again, thank you for being here. You are excused. And, I've always told jurors you certainly have the right to discuss your observations with lawyers. Sometimes the lawyers would like to see input, but you do not have to. If anyone contacts you in any way about this case and you feel uncomfortable about it, you call back in through the clerk's office and I will take care of it. But you're free to discuss the case with anyone at this point that you see fit. Again, you certainly have the right not to discuss it with anyone. Again, thank you for being here, and maybe we'll show you out.
Well, I think first, maybe we start to go through the exhibits to expedite matters. Thank you.
Quiet, please.
I would like to just go ahead and, as to the elements of self-defense, I believe Your Honor charged. Okay. With respect to the self-defense charge, it said that it was up to the defendant to show these various elements of self-defense. And of course, you also said it was the burden of proof on the state to disprove those elements, or any one of them. And I'm just would like to put on the record, I think that may be burden shifting as to this defendant being required to show, and sort of contradicts the defendant could rely on the state's failure to prove those elements. So I just want to go ahead and put that on the record that I think that may be error, and that would be our position.
Well, I guess my question to you, how would the state prove something that the defendant never showed?
Well,
I don't know how else to describe it. I mean, I understand what you're saying.
yeah, it just troubles me because, I mean, I tried a lot of self-defense cases, but I just don't remember the charge being exactly like that.
I have not changed it in the 40 years I've been
Okay.
on this. Not saying I'm right or I'm perfect, but that's what has been in the standard charge.
And I understand. I just want to, if down the road the court decides that that is burden shifting, I just want it to be on the record.
You are on the record, and that is certainly possible.
That's the extent of the argument.
Okay, otherwise, no other exceptions?
No,
Only subject to our original request, Your Honor.
Yep. All right, are the exhibits ready?
Not yet, Your Honor, we're just going back and making sure there's a clean copy of the state's 7 goes back. There was, I'm sorry, defense 7. There was Carter and the defendant, Mr. Chow. We just want to make sure that's the clean copy, the proper copy goes back. And we're just going through the count right now, Your Honor. So we'll move quickly.
can I write a couple things down?
All right, don't slow down the exhibits.
Again, you are watching our continuing coverage of Rick Chow's murder trial. Again, he is accused of shooting and killing 14-year-old Cyrus Carmack-Belton. And we are joined by a local attorney, Lacey, who's been breaking down everything that's been happening in the courtroom from gavel to gavel, really helping us understand what exactly is going on, because so many people have been watching this case. So many people, excuse me, sorry, I had a little technical difficulty there. So many people have been watching this case. And so what I want to do is I want to start by talking about what is happening right now. We were just looking inside the courtroom. There are a lot of folks holding manila envelopes. There's a lot of movement, more than what we typically see. So what is happening right now as a jury has been sent out for lunch?
So during a trial, certain things are admitted into evidence, right? We've seen the surveillance camera. I'm marking this for identification, then I move to put it in evidence, then I move to publish it. So what does that mean? Some things we mark as identification because it can't come in as evidence, but we want the witness to see it so we can ask questions on it, but that will not go back to the jury room. If it is marked for identification only, it stays, it's part of the court record to know what happened with it, but it doesn't go to the jury. It's not evidence in the case that they can consider, right? If it was admitted into evidence, it goes back to the jury room. So for example, those surveillance cameras that we saw, that will go back into evidence so they can replay it and watch it as many times as they want to. So anything in evidence that they admitted into evidence and then published to the jury will go back to the jury room. So what we're seeing right now is one of the attorneys, her name is Alyssa, she is going up to the table where all the evidence is to see if there's anything that shouldn't go back to the jury room. So if something came in that was marked as identification only, she'll of course point that out to the clerk and just say, hey, this shouldn't be in the pile, this should be in the pile, and so that way they can gather everything that is supposed to go back to the jury room.
Okay, so let's talk about what's going to happen with the jury now. We heard the judge basically read out the charges and give clarity on what means what. So what is the jury's responsibility from here on out? Because I know they get in a room, they sit at a table and they talk, but is there anything that we should know about jury deliberations that a lot of people really don't know?
I think a lot of attorneys don't know a lot about jury deliberations. One of the coolest CLEs that I've been to is when they've had like a mock trial and you see and they have the jurors and it's on camera, right? So we're watching these pretend jurors hear this fake case, and that they shorten it, of course, and then we get to see what they do to deliberate, because we don't know. So many of us have never been on a jury. I've never been on a jury. I want to. I would love to be there and sit back and listen to what goes on, but a lot of us don't know. We tell them to apply the law to the facts as they see. Sometimes jurors disagree on the facts, and if they disagree and they and they don't understand each other and people don't sway, that's when you see a mistrial. They can't agree on the facts or how to apply the law to the facts. We tell them, to listen to everything on the stand, but it's hard not to bring your own personal backgrounds into those deliberations, I would imagine. So I think it's somewhat of a mystery. I think sometimes you have jurors that, probably take everything from the judge and are able to logically do it. And I think some jurors are probably more passionate and emotional coming into it and put that into the deliberations. So I think it's a mystery.
So speaking, of the jury, there are a couple of things that could happen after their deliberation, right? So they could find him guilty, they could find him not guilty, but there are also things that could happen like a mistrial, a hung jury. So can you break down for us what are the possible outcomes from the jury deliberations?
Yeah, so some things we might see earlier than what you've mentioned is a question. Jurors can come back with questions. So for example, I've seen questions on fact and the law, and if it comes back a factual question, like when did this video, when did the police find it or something, the judge will have to say, what you heard is what you heard. You have to just remember from the testimony. But if it's a question on the law, he can recharge. So if the jury comes back and says, we're confused about self-defense of others, could you read it? He can have them come out and he can read that charge all over again. So throughout, you may see a couple of questions pop in. And then as far as outcomes from here, it will either be guilty, not guilty, or a hung jury, which ends in a mistrial. So if, it has to be unanimous, all 12 have to agree that he is guilty, or all 12 have to agree he is not guilty. If they cannot agree, if they can't come back, if they send a note that says we can't agree, what typically happens is they come in and the judge reads what we call an Allen charge. And an Allen charge basically says, we've brought you here today to decide this case, go back, go through it, talk to each other, take it, we're not asking you to change your mind. If you are firmly convinced one way or the other, we're not asking you to change your mind, but go back. If you're not firmly convinced, listen to what the others are saying, the majority, listen to them, the minority, listen to them, and see if you can make a decision. There are some Allen charges that are a little bit more persuasive and pushy to make a decision, some not as much, and you'll hear the attorneys probably argue over which Allen charge to read because there's several in different cases and how to present it to the jury. And then they go back one more time. You cannot give two Allen charges in South Carolina. I don't know if that's all states, but they can't come back again for a second time and say, we still can't make a decision, and then read an Allen charge again. If they come back a second time and say, listen, we are not going anywhere, we are at a standstill, we cannot come to a unanimous decision, at that point you will see the judge declare a mistrial.
Let me ask about this as well. How long does the jury deliberate before they can say, hey, look, we're having a hard time right now? Is there a time limit at all, or is it when the jury says, we're at an impasse, so yeah, we're just stuck? How does that work?
There's no right or wrong, like it just depends really. I have had a misdemeanor case in magistrate court, and I swear the jury was out just as long as Murdoch. You know, that the Murdoch verdict came very quick. I don't think anybody was expecting it to come back as fast as it did. And I could be wrong, you know, but I tried a case the morning, and the judge didn't get lunch because we thought, you know, this is a misdemeanor. They deliberated like 3 or 4 hours. And I feel like the Murdoch case maybe was a few more hours than that, but not much. It was within that day. So we don't know. It really just depends on these 12 jurors and what they're discussing. We don't know what they're hung up on. One person might be hung up on what we kind of talked about. How do you show malice when he was sucking vomit out of his mouth? One person might be hung up on the fact that it may be legal to run out of that store, but it ain't right, you know, over $1. So we don't know what facts they may be hung up on the most. And everybody might be different.
So they can come out and say, we haven't reached a unanimous conclusion. They can take as many hours as they want. There is no time limit for how long.
No.
Oh, okay.
And some of them might want to go back and look at things in evidence, some of the videos that they've seen. So they may get back and say, okay, we want to replay X, Y, and Z. You know, let's go through that. I want to look at this, or I want to look at that. And some jurors may go back through the evidence piece by piece before they even want to deliberate on it, just to make sure they understand everything that they are deciding, and for this case. So I think it really just depends as well there with the jurors and what they want to see. I think some jurors do want to revisit all of the evidence. In Murdoch's case, I was shocked because I don't think they had enough time to go back through all the evidence. There was so much there, and it was such a fast verdict. So I don't think that jury went through much at all if they went through stuff again. So I think that'll come into their deliberations as well, or they may go back and take a straight vote,
So it's 12:40 right now. Based off of your experience, do you think that there is a chance that we could get a verdict today, or could you see this going into tomorrow?
It depends on how heated they are and how divided. If there is a quick verdict, I would anticipate a guilty verdict. I wouldn't anticipate a quick not guilty verdict. That would surprise me. I would think if they go back there and they're pretty divided, I would say they would probably go 3-ish hours before we would see, like, we're at a deadlock, we're at a standstill, because this wasn't a ton of testimony. I mean, it was a 4-day trial, but one day was completely jury selection. We really didn't get started till Wednesday, and everything was closing. So really, you're talking about 3 days of testimony. That's not a ton of testimony to go back through. I would think we would, by the end of the day, I think we'll know if it's guilty or we're heading towards a possible mistrial.
Very interesting. I've always wondered if there was any truth in the idea of, I've heard, if they come back quickly, that means it's guilty, or if they take a long time, it means not guilty. I've always wondered if there's actually truth, or if that's just one of those sayings that just floating around that really has no substance to it.
Yeah, it's everybody's experience. When I first started as an attorney, my boss said, if it comes back quick, it's great, it's not guilty. That has not been my experience. And my experience, guilty and not guilty, for some reason, I make jurors think. I mean, I have such long jury deliberations. I don't get, and I always have jury questions. I don't know that I've tried a case without a jury question. And so I don't know, I guess something about things I say, or maybe how I say it, I get long jury deliberations. I've had jury deliberations go longer than a trial. And so, I don't know. It depends on how these attorneys, if they're like me, but that's my experience. My boss's experience was quite different. But I think if it comes back quick, it's going to be like the Murdoch case, and
Yeah.
not a good sign for the defense.
Yeah, so this is just to show, as you watch future trials that happen, it's not one size fits all. We don't know what a quick decision does or does not mean. It can really be different. Now, before we hear a verdict, we have heard the closing arguments from both the prosecution and the defense. And I want to start with the prosecution's closing arguments. I want to start by talking about really the things that you felt stood out the most from the prosecution's closing argument. What is in your mind that you were like, this was really strong, this was really poignant?
Yeah, the shirt, for sure. I think the shirt was a very good point in demonstrating that. Honestly, for me, it lacked a lot. I can't give a lot of this was great, that was great. It was just very long and bogged down. We've talked about it, how he used his notes. It is like a monologue, right? A theater production. And it wasn't as powerful when you're constantly looking down at your notes. I thought the beginning was very important. That storytelling, talking about his kids and when he was 14 years old. I think how they addressed it in closing, the gun, was very well done as well. They didn't really mention it in opening. And so I think how they talked about the gun and just owned that bad fact, was really well done in the closing by the prosecutor as well. But there was just so many strong points, and if you had just taken out retrying the case essentially in your closing and just had that emotional part about you being 14, your kids being 14, tie that into the shirt and address that bad fact with the gun, and then go through your theory and what evidence matches briefly, you could have condensed it in a more persuasive way. But I think it was just very bogged down, and I felt the same with the rebuttal. It just wasn't as impactful as the closing for the defense.
I actually want us to take a moment to listen to that, because I think one of the most powerful things that he said is when he opened, just like you said, when he started, and the first thing that he said when he approached the jury is, what is the value of a human life? In case you missed it, we're going to play a couple of minutes from the very opening of the prosecution's closing argument, and then we'll continue this conversation analysis afterwards, but take a listen.
What is the value of a human life? That's usually posed as a rhetorical question, isn't it? What is the value of a human life? Can we assign a monetary value to a human life, to a human soul? Can we put a price on it like we can a bottle of water, or a bottle of motor oil, or a lampshade, or a fishing boat? Is that possible? Are some lives worth more than others? These are philosophical questions that people have been wondering aloud for ages. Do you remember that feeling of being a teenager? You remember what it was like when your body was new and shiny? You remember that? Remember time before work and bills and all the responsibility, being responsible for other people? You remember that feeling? You remember what it was like having that long road of life just stretched out before you, and all the possibilities. Not knowing what they were, but just being excited for the ride. You remember that? Remember the last day of school? Remember the beginning of summer break, sleeping in, summer jobs, fireflies, fresh peaches? What about grandma's house? Slip and slides? Remember the smell of fresh cut grass? Beach trips, no responsibilities. How do you put a price on that? You remember that? How do you put a value on that? I've got a 15-year-old daughter and an 18-year-old son, and they're in that time of life. And if I'm waxing too poetic, it's because I'm envious at times of them, and being in that stage, and just having that whole long road of life stretched out before you, and all the possibilities. Just an adventure waiting to unfurl, right? But if I could jump in a time machine and go back to them being 14 years old, I don't think I would, because I remember the difficulties of that time as well. I remember being 14, and a sad reminder that I'm not anymore is sometimes when I get a glimpse of the camera and I see my face up there, and I say, who the hell is that? Where did those wrinkles come from? Where did that gray hair come from? But I do remember being a 14-year-old boy. And if I could, I don't think I'd go back to being a 14-year-old boy. Because I remember the difficulties of being a 14-year-old boy. I remember the idea of trying to zero in on what is my identity? What is my personality anyway? Who am I? Where do I fit in? How can I be cool? And to this day, I still remember things that I did that made me shake my head, things that I strongly regret, things that were ill-advised, things that were reckless and dangerous, things that were just plain stupid. It was not easy being a 14-year-old boy, and that was back in 1993. But that's what being a kid is. That's what being a 14-year-old boy is, to make mistakes and hopefully to learn from them, right? Isn't that what growing up is supposed to be about? I didn't look much like Cyrus, and I think that's obvious to everybody here. We grew up in different parts of Columbia. We had different experiences. We went to different schools. We grew up under different circumstances, different times. Seems that we were both skinny little 14-year-old boys from divorced parents trying to find our way.
Again, you just heard a part of the closing statement from Dale Scott representing the state of South Carolina. Now, one of the questions that I have as well is I've been rethinking everything that he said. His closing argument was about an hour, give or take. Do you think that the prosecution did a good job of connecting their argument with the evidence?
I don't think they did. I think he really just got lost in some of his notes and missed their mark. He started out so strong, and I think he really pulled the jury in. He pulled me in with the stories he was telling and talking about being a 14-year-old boy. But then I think he missed the mark. Same thing when they had that rebuttal at the end. Again, that they missed their mark, and they were even saying things that weren't said by the defense. They were saying the defense made Cyrus refer to him as a thug. I had not heard that at all. I mean, if somebody heard that, please let me know, because I never heard them refer to him that at all. What I heard from the defense in opening and in closing was that this case was very sad, and it was tragic, and it is tragic, and it is a tragedy. I've not once heard them talk about Cyrus in that way, so I felt that was kind of a low blow, kind of like yelling at Andy at the end, Dale, when he was cross-examining him, a low blow, unnecessary. I didn't like that, but I think they were just kind of lost with things and just stumbling and mumbling, and then said these things that didn't even come out in the case.
One of the things that we talked about was using objections during closing arguments. So I didn't even know that was an option. I don't think I've ever seen anybody give an objection during a closing argument. Can you speak to the fact that is a possibility, that is possible for either side to give an objection during a closing argument?
Yeah, so absolutely. It is an old school way of thinking that you do not object during a closing argument, and the reason for that is, we were taught by some attorneys where it distracts the jury, makes them look like you're hiding something, right? And we did see two objections. One, the judge never made a ruling. Byron just kept talking, but if you heard Sean, he did make one objection. And then the second objection, they went to the bench, and I'm not sure exactly, what was discussed. But you can object in a closing argument. I don't believe in the old school rule thinking, and it's because I did have a case. I should have objected. It's preserved for appeal when you object as well. I should have objected because it was a fact, not an evidence. The prosecutor was testifying to something that actually was opposite. And because it was said in closing, even though the jury instruction is that closing is not evidence, they found my client guilty. And that was, and one of the things I later learned after speaking to some of the jurors is that was one of the things they got hung up on. And, so now on, I object. If it is a fact, not an evidence, something that was, that the prosecutors make it seem like happened that did it is not substantiated, I object every time now. So I disagree with that old school way of thinking.
Yeah, that's so good to know, especially as you continue to watch other trials unfold, that option is there. Now, I want to switch to the other side, and let's talk about the defense. One of the things that I think arguably a lot of people could agree on is that Sean Kent he put on a production, right? He very much had a powerful, arguably a very powerful closing statement. How would you compare his to the prosecution's?
He knows his case. He knew his case. You knew that he knew his case. And that's one of the things we talk about is, you can use your notes and have notes and use them effectively in closing. Sean would completely disagree on that. He says no notes ever. You can use them if there is a point to them. And you just see briefly, he used a transcript. I think it looked like to read something word for word. And again, it was powerful when he did that because he didn't have notes. So when he did use that transcript, it was a moment. Substantially different from the state. They had notes. Even at the end, Byron's like, oh, hold on, let me go back and look and see. It just to me, it looks like they don't know their case as well, or they don't believe their case as well. And that's how I would feel as a juror. Sean knows his case. He knows what evidence, and he went by piece, matching what the defense said, what their defense was, and which evidence backed it up. Even to the point of rolling on the ground, we saw him. And then we saw Byron copy it, but by that point, it wasn't original. But you could tell that Sean knew his case. He was prepared. And I even joked, I said, if he didn't cuss like I know he does, he would be a great preacher because he just commands attention. He's so powerful. He knows when to raise his voice, when to lower it, and really bring you in. I was very invested the whole time. I didn't get lost. It was a lot shorter and condensed. So I think he did a great job.
And speaking of Sean, you talked about the fact last week that closing arguments, his specialty, like he is known for delivering very powerful closing arguments. And in case you missed his closing argument, we want to share a piece of that with you right now. Just listen to a couple of minutes of the closing arguments, again, coming from defense attorney Sean Kent.
Use your common sense and listen to the evidence, but listen to the witnesses and listen to what they have told you. Murder, as the state has told you, is the intentional killing of another human being with malice aforethought, without self-defense. We have just showed you self-defense and defense of others. The state has melded a little bit of those theories together, but you need to make sure that you understand. One, without fault and bringing on the difficulty. Again, I've explained to you that you have a legal right to follow somebody. Whether they like what the law is, that's what it is. And as you're going through that, then you have to talk about imminent danger. And this is from the eyes of Andy. And they're trying to mix the two of the things together, but it's under the eyes of Andy at this point. As Andy, does he have a fear of imminent danger? Was a gun pointed at Andy? Would Andy, who had withdrawn from the conflict, you got it, I'm over this? No. Would Andy have had a right to point the firearm and save his own life? Reasonable person. A reasonable person in the same situation, what would they have done? And we can take that two ways if we want to argue the state's theory. Way one, Andy, gun pointed at you. Would he have had a right, as he was sentenced, remember that knife in the back situation? Andy would have had a right to fire to save his own life. But more importantly, the reasonable person's situation, Rick Chow would have had a right, and did have a right, to save his son. The strongest evidence that was given in entire this case is when the officer got on the stand and I asked him that question. And I said, have you ever fired your firearm? No. Have you had a firearm pointed at you? Yes. I didn't fire. What if someone was pointed at your loved one? Yeah. I asked that same officer the situation when officers are chasing somebody and you chase them incorrectly. Remember we asked him that question. You chase somebody incorrectly, what happens? We chase them incorrectly, it does happen. And what would happen if that individual pointed a firearm at you? Remember the example he gave? If someone pointed a firearm as I'm chasing them incorrectly, well, I would tell, and they turned around and pointed a firearm at me, I would tell them, stop, drop it. And if they did not drop it, I would fire. It sounds eerily familiar to this case. And that's some of the rest of the story that the state of South Carolina, for some reason, has chosen not to tell us today. And then we go, duty to retreat, or can you retreat? As a person is pointing a firearm at you and you're pulling backwards and someone is saying, stop, no, don't. That's what duty to retreat is. No one turns and runs. The judge is going to tell you, as I mentioned, as we're talking about self-defense, and I've said it several times, you have a right to act on appearances, and you have a right to be wrong. So as we sit here and we're in Rick Chow's position, we're wondering what Rick Chow is doing. As we've heard this testimony, Rick Chow sees a gun pointed at his son. His son says, as you heard, I was afraid, I was terrified. He's got a gun, he's got a gun. So Rick Chow in that situation stands in the place of his son. This case is not about a dollar. This case is not about a shoplifter. This case is about a father who sees a gun pointed at his son and had to make a decision.
Defense attorney Sean Kent, a couple of minutes of that closing argument. Now, is there anything when it comes to the closing argument from Chow's defense that you were like, I think they left this on the table?
There was one. At the end, their last witness was very impactful from the defense, where she was talking about how Rick Chow was sucking vomit out of his mouth to try to save his life. And for me, that's very powerful when determining malice. Mm-hmm. You know, it's hard for me, it would be, and as a juror, would be hard for me to say that there was malice, that he stumbled upon this shoplifter. It was like, you shoplifted, I'm gonna, pull the trigger because you shoplifted from my store, because that's the state's theory. To get malice, you have to believe, even for a split second, that Rick Chow wanted to shoot him for taking a bottle of water. And so when you hear that testimony that he was sucking vomit out of his mouth, I don't even know that I could do that. I mean, I would hope I would do anything to save somebody's life no matter what, right? But that is so gross to me. So for him to do that to this person that he doesn't know, for me it would be hard to navigate malice with that fact. And I thought that was an incredible witness. That was the only part I thought they missed the mark on. Everything else was great. And I wanted to point out, from just rewatching parts of his clip, one thing we try to do in a closing is repetitive things, because that's what the jury takes back. The rest of the story. You start off with the rest of the story, and throughout he ties this evidence, the rest of the story, the rest of the story. That was very well done, as well as he used the state's closing against them. Cameras don't lie. Cameras don't lie. So it was very intentional and well done that he stuck to the rest of the story. You could tell that was their theme and theory of their closing. He connected every piece to the rest of the story that the state didn't show the jury, which doesn't look good, right? As well as, cameras don't lie. We tie that in. Cameras don't lie, but the state didn't show you the rest of this footage. We had to bring in a witness to do that. They want to say cameras don't lie, but yet they don't want to play them, right? Mm-hmm. So you didn't hear that repetitiveness, that theme. Like, I don't know what their theme and theory was for the state, because they didn't have that. But I think everybody that watched Sean, if you would have talked to them, hey, what exactly did you, well, the rest of the story, they didn't tell you that, you have that because of that repetitiveness. That was one thing, just watching the clip back, what I thought was worth bringing up. That was well done.
let's talk about the rebuttal. And I specifically want to talk about the choice that Attorney Dale did not give the rebuttal, but we saw Richland County Solicitor Byron Gibson give the rebuttal. Is that normal to switch off for a rebuttal? And were you surprised by that choice?
I don't think that is normal. I think whoever gives the closing also rebuts. I was surprised at that choice. I didn't expect it when he stood up to rebut. It did surprise me. I think it's a political move, though, to be honest. I think he wanted that rebuttal, that last fight for this case and for Cyrus, as we know they're elected officials. So I think it was a strategic choice for career purposes, not necessarily this trial.
When you are sitting down with your prosecution or defense, and we know that closing arguments are one of the most important parts of a trial, it's those lasting words that you leave with the jury. How do you determine who is going to give the closing argument?
I think it's just a discussion with one thing with me and my law partner, and even my associate, we know what our strong suits are and what's not. So I think when you're with your team, whatever that team is, it's a discussion. As we've mentioned before, Sean is known for his closing arguments. So I would imagine as soon as his team was put together, the first thing that was said was Sean is doing closing arguments. That is what he is, the best at. One thing with me and my law partner, we were trial prepping a case. I can't remember which one at this point, but there was a witness that was on my list, and I immediately said, Laura, this witness needs a harsher tone. That is you. You give a better, she can go there, whereas my personality, not as much. It kind of depends. And so she's like, you're right. And I said, in this one, she's like, you have to take it, because you're a mom and you have that empathy. And not that she doesn't, but, so we actually ended up changing things around based on our personality. So I definitely think, like, as a team, you know what you're best at and what your weakest is. We're not best at everything in a trial. We have our strong moments. We've seen that with all the attorneys in the case, strong moments, weak moments. So I think when you're crafting a team, it's like navigating a play, a theater production. It's, casting who goes where when you sit down at the table.
Yeah, when you also are looking at closing arguments, do they carry more weight than, let's say, an opening argument or the witnesses that you bring on, or is everything equal?
I think a closing is most important, and Sean would agree. Sean is always be closing. Always, give information from the witness that you're going to put into your closing argument to wrap everything nice in a bow and give to the jury, right? So I do think the closing is the most important. Interesting, and one thing we've used to fight over, and there's rules on who gets to close, is, defense attorneys, we think we should get the last word. It's our client that we're representing, so we should get the last word before they go back to the jury. Prosecutors think differently. The burden's on us. With, the burden of proof was we should get the last word. So, there's actually been rule changes on who gives the closing last and, who has to go first. There used to be big fights about it. This is our current rule where the state closes in full and then gets a rebuttal. When I first started practicing, we didn't have that rebuttal. So that, is something that we still fuss about. I think the defense should go last, but I bet you get a prosecutor here giving their analysis and they're going to argue, the opposite.
When you are looking at the jury, what are you looking for? Are there any signs that a jury member may give that can kind of give you an idea of where they're leaning, or how can you tell that a jury is engaged?
Yeah, eye contact is the biggest thing. So sometimes I'll, one thing we're taught is don't just talk to like the group, like make eye contact with different points of your, closing. And so sometimes I'll look at somebody and they're like, I'm like, they're with me. They're nodding. And I don't even pay attention to it in the moment. I'll actually get back to the table, and whoever I'm trying the case with, like juror 4, 6, 10, they were all nodding with you. They're with us. And then you have some, I'm giving my point, and they're like this. And I'm like, oh, I have lost
Yeah.
them. They're
Oh,
not
yeah.
with me at all. So you can tell. I think it's easier for the table watching me giving the closing argument to see which jurors are with me and which aren't, because you're just in that moment.
Yeah.
But you can kind of tell, especially if you're on the outside looking in, kind of where each juror is at least starting, right? Before deliberations, kind of where their mind is starting at before going to that room.
And I want to talk about this, putting yourself in the shoes of the defense. What would you be telling Chow right now as they are waiting to get that verdict back? Do you think that things have been going good for the defense? Is it just really up in the air? Like, what would you be advising Chow right now?
I wouldn't be advising anything, honestly. I have seen jurors do wild things. I've seen them convict someone I firmly believe is innocent. I've seen them find somebody not guilty that I think was. And so, you know, I think everybody in that courtroom has seen jurors do the same. So I wouldn't advise him. I think for me, I would just offer some comfort. You know, I know this has been a really long week. It's been a really long 3 years. You know, do you have any questions? I would see if he has any questions procedurally. You know, and if he asked, you know, what do you think? I would just say, I don't know. You know, it's all up to the jury. You know, if they have a question, they'll bring you back up here and, you know, we'll just take it moment by moment. But I wouldn't be telling him, oh, this is a slam dunk, you know, or vice versa. Because we really just don't know what these jurors are going to come back with.
Based off of the arguments that are presented throughout the duration of this trial, what could you see happening when it does come to a verdict? I know it really is a guess because we have no idea the life experiences of these jurors, where they come from, who they are. Like, we have no idea outside of the fact that they are a representation of our community. So what would, based off of what you've seen, what could you see happening? What would be your best prediction? Or is it too close to call?
It's too close to call, but if I was put in a corner, you have to decide. I would say a mistrial at this point. I think the state had a stronger case of manslaughter, and they could have chosen to go that route. They didn't. I think it would be a stronger case, I think, if they had put manslaughter on instead of murder. And in that situation, I think there would be a verdict of guilt, or at least a stronger chance. But they chose to do murder, and the defense chose to go all in or nothing without asking for any lesser included. So at this point, like I said, I struggle to see malice with the life-saving measures. He did have a gun on him. I think they're going to teeter between that and no, they were within their legal right of leaving the store, but it wasn't the right decision to make. And I could see them getting really hung on those two things and not being able to make a unanimous decision.
When you look back over the trial from opening statements to closing, gavel to gavel, is there anything that's happened in this trial that was surprising to you or that really stood out?
Yeah, I didn't know a lot about this case. You know, I think they moved to change venue because of the attention. I practice here, criminal defense, that's all I do, and I did not know a lot of the details about this case until it started. When Jack got up there and mentioned that Cyrus had a gun, I had no idea about that. I had not heard that piece of information at all. So as the jurors have learned about this case, I have too. I had not heard much about it. I knew, you know, it was a store owner and a 14-year-old boy. I've learned the chase. I didn't know how long that was. So there's a lot of information I learned, you know, alongside the jurors throughout this week.
And then I want to, for folks who are just coming in, I also want to talk about what happened at the very, very beginning. We talked about it earlier this morning, a couple of hours ago, how the court opened this morning, and it didn't start with closing arguments right off the bat. It started with the defense asking the judge to question each juror one by one and ask them if they saw anything, engage with anything that may improperly sway their vote when it comes to making a verdict, because the jury was not sequestered this weekend. They basically were just told, hey, you know the rules, don't talk about it, don't look for it on social media, any of that. Can we break down what happened this morning with that, and if it's rare or unusual for defense or prosecution to say, hey, I want you to bring the jury out and ask them one by one, have they done anything they shouldn't have this weekend?
It's not normal, but I think it was important and should have been done in this case. It's a case-by-case basis, right? if this were a 2-day trial and, Monday, Tuesday, and we're giving the case to the jury on Wednesday, I don't think it would have been proper at that point, because they're not going the weekend. What made this important, and I think the judge should have done it, was because it went over the weekend. That's a long amount of time for these jurors to sit, and you're asked not to talk about it to anybody, not to get on Facebook or Instagram, social media. And like Joe said, it's a good point. We've sequestered witnesses when all you had was local news. And that's the only thing you had access to. And now we have access to so much more information. The comment section. I'm getting comments. My firm, I see Sean on his TikTok talking about another case. In this case, there's comments on this case, very biased comments. And so I cannot imagine those 15 jurors not accessing some type of information over the weekend that could have affected their decision. So I think it was the appropriate request.
Yeah.
I think the judge should have done it. It's not something that you want to set precedent to do in every case. I don't think it's needed in every case. And Judge Taylor could have said that. I find this appropriate here. Of course, if this went Monday through Friday, I wouldn't. But because it was the weekend and with access to social media and how polarizing this case is, I think it's appropriate here. So he could have done it and still not set a precedent that he's doing it every time.
Yeah, I think too, one of the things that stood out to me about this trial is just the timeline of it. Not only did this trial take place on the 3-year anniversary of Cyrus's death, but also this is a trial that lasted over the weekend. They had that break Saturday and Sunday. So I think the timeline has been interesting in of itself. Do you think that even the timing of a case can play a part in what the verdict comes out to be? Do you think the timing in this case could play a part in what this verdict turns out to be?
I don't. I think it definitely affects the family emotionally going through all of this, reliving it. 3 years to the date. So I definitely think it is harder for them, to be honest. But as far as the jurors go, and it really wasn't made that big throughout the trial that it was 3 years to the date that one of these trial days fell on. So I don't think it's going to play into the jurors' decision.
What about that weekend?
This
past weekend, like the trials stretching from last week into this week. Now, do you think the timing of the trial in regards to having a weekend off could play a role in that?
Absolutely.
Yeah.
Absolutely. I think if there is a verdict of guilt, and they do decide to call jurors, if the jurors are willing to talk to the defense, I would be shocked if you hear that those 12 jurors stayed off social media. Shocked.
Okay. And then I want to talk about that. So the defense can the defense and prosecution talk to jurors afterwards and ask them why they made the decision that they made?
They can. So you have to. So the judge will let them know that somebody may reach out to them, but they do not have to talk to you. You do not have to talk to them as a juror. So he will let them know at the end of the case. But then the prosecution can call, the defense can call and ask those questions, but they do have to say, listen, I am with the state or I'm with the defense. Are you willing to talk to me? Is that okay? And if they say no and you keep going, you're going to be in trouble.
Right.
It is. Do they want to talk to you? If they say no, you let it go. You can't push. That could be seen as harassing a juror. Or if they say yes, then of course you can engage in that conversation.
What is the purpose in talking with them afterwards? Is it to, let's say if there is a guilty verdict, is it to prepare for an appeal?
Yes, possibly. Or a motion for a new trial. So that's what we saw again in the Murdaugh case. They talked to the jurors after, found out about what was kind of going on with Becky Hill, and then we saw this motion for a new trial. So one thing you may do is if you do see a guilty verdict, if they talk to these jurors and like, well, yeah, I saw those comments and they really wanted my community to find him guilty, so I felt I had to. So if you get something like that, then yes, you're going to file that motion for a new trial. If that gets denied, that's going to be one of your bases for appeal. So I think that's important. Also, it's important, I think, if it is hung. Because what if it's a hung jury, right? And the state calls, there's a juror willing to talk, like, yeah, we were hung 11-1 not guilty. What would that tell you? That's going to tell the state, hey, we might not have a strong case for murder. What should we do at that point? That may change their stance on the case, in moving forward and deciding to retry it or not.
I think that's very interesting. I don't know that that's common knowledge that the defense and prosecution can talk to the witness or the jury members afterwards. One of the things that I want to ask you about as well, and we've been talking about this is one of the most high profile cases that we have seen in our area, specific to our area in a couple of years outside of the Murdaugh trial. How does the high profile nature of this case impact the trial? If at all?
I think it definitely affects who's trying this case by the state.
Yeah.
I don't know if we would see Byron up there if this weren't high profile, being televised on court TV. I think it definitely affects how the state navigates the case. I don't think it affects the defense as much. You know, one thing I point out, people hate on defense attorneys, you know, for whatever our clients did, allegedly did, you know, whatever. But I have represented people that, you know, were accused of doing horrific things, but I've learned so much good about them. You know, people, oftentimes there's so much good about somebody, but they do something bad. And we say somebody shouldn't be judged by their worst day, right? That's one thing I've said, of course, during a plea before. These people know Mr. Chow on a different level than we do viewing this trial, than the jurors do, the judge, the prosecutors. They spent 3 years talking to him, talking to his family. I'm sure they could sit down and tell you a lot of great things that he's done in the past. They know his personality. So taking on this trial for the defense and the courts being there, I don't think it matters whether they're there or not. You know, they know who this person is. They, you know, believe in their theory of the case. Whether it's not going to affect them. I do think it affects the jurors, you know, and that's why it's hard for me to believe they're not on social media. With it being a high-profile case, the cameras are there. Don't you want to know what people are saying about the case in your community? Aren't you curious? So I could see somebody's curiosity getting the best of them and going and look because the cameras are there. Because some may feel like they're supposed to make one verdict over the other instead of basing it on the evidence. So I think it could affect jurors.
Yeah, and I'll tell you this, and we were talking about this. I mean, this trial is everywhere. If you didn't know about what happened 3 years ago, you absolutely know in our community about what is happening right now, because so many people are talking about it. So many people invested in it. And one of the things that I've noticed too is it's been a very polarizing trial as well. There really is no like gray area at all. People either believe that he's guilty or believe that he's not guilty. And speaking of guilty, not guilty, I want to kind of look ahead and look at the options of what happens next. So what happens next if he's found guilty? What happens next if he's found not guilty? And then what happens if there is a hung jury?
Sure. So if he's found not guilty, he'll be released. I would imagine today. So that's what happens there. They can't retry the case. They can't come back and say, okay, well, they found him not guilty on murder. Let's indict him for manslaughter now. You can't do that because jeopardy attaches. You know, we've heard about double jeopardy. So at that point, it's done and over. As far as if he is found guilty, what I would imagine is you may see a motion for a new trial, grounds for that. Sometimes we see those motions right after, like once the case is done, hey, Your Honor, we make a motion for a new trial because of X, Y, Z. You have either 5 days or 10 days. I have to double check the rules to file that, but some may file it and say, you know, schedule it later on because they want to talk to the jurors, make sure that they have all the grounds that they need. From there, you will have an appeal. So if there is a motion for a new trial or not, or the motion is denied, an appeal. And so what they're going to look at is something like what Jack did at the end. He objected to the self-defense charge. Well, was that self-defense charge prejudicial to the client? Is that not the law? Should it have charged, you know, was it trying to persuade the jury instead of just giving a neutral, this is what our law is? And the Court of Appeals will look at it and they could reverse. If the appellate court says, you know what, everything was fine. So an appeal are errors by the judge, right? Not the lawyers. So an appeal is, hey, this should have come in or this should not have came in. The judge made a mistake. So that's what the appellate court is ruling on, is did the judge let something in or not let something in, and it prejudiced the case, essentially, in your most basic forms. Okay, so if they said the judge didn't make any errors of law, then you could get into what's called post-conviction relief. So post-conviction relief is ineffective assistance of counsel did my attorneys mess up in the case? So it's very long and very lengthy.
Yeah.
And again, it's why you want a competent defense attorney, whether you believe somebody's guilty or not. You want somebody competent, because if someone is guilty of a crime, no matter what crime, a good defense attorney will hopefully preserve it to where there's no reversal and appeal, there's no ineffective assistance of counsel, and it's not going to come back, right? But those are what you could see if there is a guilty verdict. If there is a mistrial, we don't know. If it's a hung jury, I don't know what the state will do. I imagine they'll retry it. How soon, we don't know. But we already know that they're, of course, going to retry the Murdaugh case. So I would imagine they would retry this again.
Yeah. All right, my friends. So again, breaking down analysis of what we saw today in the courtroom, those closing arguments, and both really leaving the jurors with a lot to think about. And right now, this case is in the jury's hands. I think that the court of public opinion has already decided what they believe. But at the end of the day, this boils down to, did the state of South Carolina prove that Rick Chow is guilty of murder? And so when it comes to deliberation time, we have no idea how long that will take, but we do know that we will have coverage of it as soon as they come back with that verdict. And of course, continue to bring you analysis of what led to whatever decision that they made, whether it is guilty, not guilty, or a hung jury. Again, this is a situation where arguably people could say it's too close to call either way. But we have full coverage again on WLTX.com. Everything that has happened from this trial, from the very beginning with opening arguments and jury selection, all the way down to just a few hours ago when they did have those closing arguments. You can find that on our website, WLTX.com. We will be back once we get more information or have further analysis to break down. But until then, make sure to stick with News 19 and check us out online as well for everything you need to know about the murder trial for Rick Chow. And again, we will bring you that breaking news coverage as soon as we learn where the jury stands when it comes to a verdict.
And we're going to look live inside a courtroom at the Richland County Judicial Center where Rick Chow, a defendant in the murder case in the death of Cyrus Carmack-Belton, has just re-entered the courtroom. The jury, we understand, has a question about this case they want to ask the judge. There's Joe McCullough and Jack Swerling, the defense attorneys. The Fifth Circuit solicitor is at his desk. Let's listen in live now to see what's going on.
With y'all's permission, I think I'm gonna ask the forelady exactly what part of the instructions they want. I don't know that it would be necessary for them to hear, my job, their job, and all that, all over again.
Are you envisioning something like, you don't have a specific section?
Judge, you gonna just call foreman in, forelady?
I guess maybe, let's start it that way. That suit everyone, just bring in the forelady?
Those are me, yeah.
Okay.
That's fine.
All right, just bring in the forelady, please. Yeah, and just for the record, I marked the note as court. Madam Forelady, we got your note about wanting us to read instructions again. Is there a specific provision in the instructions you have in mind, or does the jury want to have the entire thing read again?
They do not want the entire thing read again.
Okay.
We didn't know that we could have a portion of it read,
Okay.
but we did want to go over the aspects of malice, what constitutes malice.
Okay. All right, that was it?
Yes, and someone had spoke about what is the charge of murder and what are the things that would make him guilty of murder.
Okay.
And I think that's one and the same one we're talking about.
All right. Okay, well, that's what we need to know. If you'll step,
Okay.
well, you can just stay.
Okay.
And you can get, what I think I'll do is I'll just read the entire murder section, and stop after that before we get into this, because I think it flows right into separate now, so I'll just stop the section. Unless anybody has anything. All right, if you want to bring in the remainder of the jury, please, sir. Yes, sir.
Jury seated, Your Honor.
Thank you, sir. All right, ladies and gentlemen, jury, understand you would like to be recharged on how we define murder. So I'm going to recharge you on the murder portion of the instruction. The defendant is charged with one count of murder. The state must prove beyond reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the evil intent and the act. Malice aforethought may be expressed or inferred. These terms express and infer do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is, either by direct evidence or by inference from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, lying in wait for a person or any other acts of preparation going to show that the deed was within the defendant's mind would be express malice. Malice may be inferred from conduct showing a total disregard for human life. If facts are proven beyond a reasonable doubt sufficient to raise an inference of malice to your satisfaction, this inference would be simply an evidentiary fact to be considered by you along with the other evidence in the case. You may give it the weight you decide it should receive. And that's it. I'm going to excuse you back to your jury room, and if you have any other questions, if you need anything else, just let us know.
Thank you.
All right. All right, any exceptions from state?
No, sir.
Anything for the defense?
No, sir.
All right, we'll be at ease.
All right, so there you have it. The jurors had a question about what constitutes malice when it comes to the murder charge, and the judge reading the charge to the jury again about what constitutes malice when it comes to murder. The jury deliberating now for maybe 90 minutes or so, we believe. The 12 members trying to decide whether or not Rick Chow is guilty of murder in the August 2023 death of Cyrus Carmack-Belton. Some powerful closing arguments early today from both the prosecution and from the defense, and we'll be breaking that down as the afternoon progresses. But again, we are waiting. The jury is going back to the room to deliberate more, trying to decide the fate of Rick Chow, the former gas station owner accused in the August 2023 shooting death of 14-year-old Cyrus Carmack-Belton. We'll continue to monitor what's going on in the courtroom. We'll be back on the air with any new developments. All right, we are back on the air because we understand the jury in the Rick Chow murder trial.
Jury seated, Your Honor.
Thank you,
What's on?
sir.
Let's listen in.
I received your note, and I appreciate the information. And basically, it seemed like an update of sorts. So
Yeah.
what I'm gonna ask you all to do is just, and I've shared as much as I could with the lawyers. What you folks do back there is none of any of our business, so I didn't share it all. But I'm gonna ask you to continue working. If there's anything we can do to make you more comfortable, snacks, drinks, just let the bailiffs know. And I'm gonna ask you to continue your deliberations, and we'll be here if you need us. All right?
Well, it certainly sounds like the judge is sending the jury back to deliberate more. I'm going to see if they says anything further to the state and to the prosecution here.
Any exceptions from the state?
No, sir.
Silence? No. All right, we'll be at ease again until further notice.
All right, so once again, the jury apparently sent a message of some sort to the judge in the case. The judge sending the jury back into the room to continue their deliberations. We don't know what exactly has transpired as far as what message they sent. We do know about 90 minutes or so ago, the jury did come into the courtroom and they wanted a definition of what malice was in the murder charge against Rick Chow. Chow, of course, standing trial for the August 2023 shooting death of 14-year-old Cyrus Carmack-Belton, as Chow is now being led out in handcuffs back to the holding area while the jury continues to deliberate. There were some powerful closing arguments today from both the prosecution and the state in this case. We have a lot of that posted for you on our website, WLTX.com. We're continuing to monitor the situation at the Richland County Courthouse. As soon as we have some new developments, we'll of course pass them along to you right here and on WLTX.com. Back on the air, there you see murder defendant Rick Chow as the jury has been deliberating his fate now since about 1 o'clock or so this afternoon. And in that time frame, they've had a couple of questions for the judge. They had a question around 3 o'clock or so about what a malice was when it came to the murder charge. And then around 4 o'clock or so, they sent some sort of note to the judge. The judge in court only acknowledged to the jury that he received their note and he was sending them back for further deliberations. The jury in this case can find him guilty or not guilty of murder. And the fact that they've been having some questions in this case may point to the fact that the jury has some serious deliberations going on with some serious questions right now. Chow, as you know, is charged with murder in the 2023 shooting death of Cyrus Carmack-Belton outside the Park Lane Road gas station that Chow owned at the time. Investigators with the Sheriff's Department said that Chow accused the teen of shoplifting water bottles before chasing him from the store and fatally shooting him. Now, we did have those closing arguments earlier today, and there were vastly different closing arguments. Just to give you some highlights about what was said in court during those closing arguments today, Fifth Circuit Solicitor the Fifth Circuit Solicitor's office, I should say, Dale Scott, spent more than an hour walking jurors through the state's theory of the case, arguing that Chow's own actions led to the deadly confrontation between him and Cyrus Carmack-Belton. He says there is only one verdict that speaks the truth. The verdict, he said, is guilty. He repeatedly returned to surveillance footage shown during the trial, arguing it demonstrated that the young man never stole the water bottles that prompted that confrontation. The defense, meanwhile, also giving a strong closing argument to the jurors. Sean Kent repeatedly challenging the prosecution's characterization of the case, telling jurors the state had focused too heavily on allegations that Cyrus Carmack-Belton was suspected of stealing water from the family's gas station. He told jurors that if Rick Chow shot a man in the back stealing a $1 bottle of water from his store, you do what you will. Taking a human life, he said, over a bottle of water is absolutely ridiculous. But he argued that that wasn't what happened here. Using the theme of the rest of the story throughout his closing argument, Kent accused prosecutors of leaving out evidence that supported the defense theory of the case. He pointed jurors to the 911 calls, the body camera footage, and statements made by Rick Chow and his son Andy Chow shortly after the shooting, arguing those recordings consistently showed both men reporting that Cyrus Carmack-Belton had a gun. He said that we don't want you to hear what Rick said at the moment, at that time, without a lawyer, without anyone telling him what he had to say. Again, criticizing the state's presentation of evidence in this case. The defense also challenging the credibility of some eyewitness testimony presented by prosecutors, arguing that certain witnesses gave accounts at trial that differed from statements that they gave right after the shooting. A major focus of the state's case involved the Chows pursuing Cyrus Carmack-Belton after he left the store. Prosecutors argued the pursuit created the confrontation that ultimately led to the shooting. The defense countered by telling jurors that while they may disagree with the decision to follow Cyrus Carmack-Belton outside the store, it was not illegal. He told the jury the question isn't, do you think it's right? The question is it legal? The defense also argued that even if jurors believe the Chows helped create the confrontation, South Carolina law allows a person to regain the right to self-defense if they withdraw from a conflict. And according to the defense, testimony showed Andy Chow backed away and Rick Chow yelled for Cyrus Carmack-Belton to drop the gun before the shot was fired. The defense says that is a clear withdrawal. Now, the Fifth Circuit Solicitor did have a chance to have a rebuttal. During that rebuttal, the Fifth Circuit Solicitor, Byron Gibson, directly challenged the defense attorney's claim that the case was about a father protecting his son. Instead, he argued the evidence allowed 14-year-old Cyrus Carmack-Belton, or showed that the 14-year-old was running away when he was shot in the back after being chased from the family's convenience store. Gibson telling jurors that the question still remains, what is the value of a human life? He accused the defense of trying to portray Cyrus Carmack-Belton as a dangerous teenager, while ignoring testimony from eyewitnesses who said they never saw the teen point a gun at anyone. The solicitor repeatedly pointing jurors to testimony from several witnesses, arguing that none of those witnesses supported the defense claim that Cyrus Carmack-Belton pointed a gun at Rick Chow or his son. He also emphasized testimony that Cyrus Carmack-Belton dropped a shoe, 2 cell phones, and his backpack while fleeing, saying those actions alone showed a frightened teenager trying to escape 2 pursuing adults. The solicitor also disputed the defense argument that the Chows had withdrawn from the confrontation before the shooting, telling jurors that witnesses described the men continuing to advance toward Carmack-Belton, saying they ran after him, they caught him, that gun spilled out, and that man made a rash decision. He overreacted. Again, that's the Fifth Circuit solicitor's words to the jury today. He ended his rebuttal by asking jurors to find Chow guilty of murder, arguing the evidence showed that Cyrus Carmack-Belton was shot while attempting to flee. He added that Rick Chow is guilty of the murder of the 14-year-old in this case. So again, following the rebuttal, Judge Heath Taylor prepared to instruct jurors on the law before those deliberations began, and he did charge the jury right after lunchtime today, the jury getting the case right around 1 o'clock or so. We are awaiting the jury to return. We understand they do have a question that they would like to ask the judge in this case, or they may have another note they need to give the judge in this case. It's not quite clear what that is right now, but as we again continue to look at this live picture inside the Richland County Courthouse, the defense making a big decision, a bold decision in this case last week when asked by the judge what they wanted the jury to be charged with. What would the jury be able to decide? Would the jury be able to decide that he was guilty but perhaps not of murder, maybe manslaughter? But they decided it's an all or nothing here, the defense did. They decided all or nothing. It's either guilty of murder or an acquittal. Manslaughter is not on the table in this case. Again, the jury did have that question, probably around 3 o'clock or so this afternoon, 2:30 or 3 o'clock this afternoon, indicating that they wanted the judge to instruct the jury again about what malice and forethought is when it comes to the murder charge. So the judge read to them again what malice was in this case and instructed them to go back into the jury room to deliberate more. That was around 2:30 or so. And then right around 4 o'clock, right around the 4 o'clock hour, we understand that the jury sent a note to the judge, and Heath Taylor, with the jury in the courtroom, instructed them that he had received their note and that he was instructing them to go back to deliberate further in this case. All right, so that was right around 4 o'clock or so this afternoon. Here we are at 10 minutes until 6. And we believe the judge is getting ready to walk back into the courtroom now. And he's not quite there, but we do see Jack Swirling and Joe McCullough coming in right now, and we see the Fifth Circuit solicitor. We understand that attorneys were taken back into the judge's chamber that is just a few moments ago. All right, the judge is on the bench. Let's listen in now to see what's going on.
So we're clear on the record, we gathered in the chambers. We let y'all know that we received another note which I believe also contains some of the deliberative process of the jury, which I am not comfortable disclosing within, are basically consistent with South Carolina law. It's not. So I'm going to, and I can say, mention that at least some had indicated they may want to go home for the night. I'm not inclined to do that. This case has garnered a significant amount of media attention. I would be concerned that the jury could somehow be compromised or researched or something. So now that we've started the process, I'm going to ask them to push on through and go ahead and order dinner. Any objection now from the state?
No.
No, we concur.
Okay. All right, bring him in, please, sir.
Yes, sir.
Received your note. I understand some folks may be getting fatigued. This has been a long day, long week. Typically, once the deliberative process begins, we ask you to stay here as long as possible. Certainly, we're not going to do anything inhumane, but I'm going to ask you to keep deliberating. The clerk is going to get with you shortly with regard to orders for dinner. And we're just going to ask you to keep working. I understand it's been a long day. It's been a long day for everybody. And I know y'all are diligently working, and I appreciate that. But we're going to ask you just to keep working, and we'll get your dinner orders, and we'll just let us know if you need anything else. All right. Thank you. Any objections from the state?
No.
Defense?
No.
All right, thank y'all. Let us know.
Right, so here is what is happening.
Yes, sir.
The jury has been deliberating the case since about 1 o'clock or so. As we continue to look live, there you see the defense attorneys and the solicitor's office attorneys. They are approaching the bench now, talking with Judge Heath Taylor. As the camera zooms in on the defendant here, Rick Chow, he's being handcuffed. He'll go back into the holding area. Apparently, some members of the jury were wanting to go home for the night. They have been deliberating since about 1 o'clock with no conclusion in this case just yet. The judge is not doing that. He does not want the case compromised in some way, and so he is ordering supper for the jury, and the jury is going to continue deliberating this evening. We have covered a number of trials over the past few years, and I can tell you in some instances juries have deliberated until 10, 11, 12 o'clock at night. It's as long as the judge says they can deliberate. We're not sure what to expect in this case just yet, but the judge clearly believes that the jury needs to deliberate further. He is not letting them go home for the evening. Some had wanted to go home and come back tomorrow and continue, but again, that is not the decision of Judge Heath Taylor right now. He is sending the jury back to the room to deliberate more, hash out the case a little more, talks amongst themselves again, try to come to some sort of conclusion in this case. We are going to continue to monitor this for you throughout the evening hours. As soon as we have an update from the Richland County Courthouse, we will be back on the air for you. And of course, for complete coverage anytime, simply go to our website. That's WLTX.com. All right, Erica, thank you so much. Let's talk about what's been going on here. About an hour or so ago, the jury sent a note to the judge. Some of them wanted to go home for the evening, but the judge was not inclined to do that. Instead, he is getting them some supper and he is sending them back to deliberate further. So what do you know about what's going on?
I believe that's the absolute right call. In today's age with social media, the influence of, even if they don't mean anything malicious, but significant others, family members, making any type of comments about something they've seen or heard could absolutely influence a juror's verdict. And coming off the heels of the Murdaugh situation, and it was even referenced by Judge Taylor, and they've had these multiple jury notes. It's the right call. Keep them deliberating, have them make a decision. Sending them home only creates problems. It's a situation where ultimately, if they come back again and say that they're undecided, a split, or hung, then the judge will give them what's called an Allen charge. We, in the legal, call it a dynamite charge, because it's basically telling the jury, look, all we're going to do is try this case again, find 12 new people, go back there and try to figure it out. And if they come back again and say they can't make a decision, that they're still hung or still split, then it's a hung jury.
Obviously, you believe the jury right now is wrestling with that at the moment, because I think they got the case around 1. About 90 minutes later, they had a question for the judge about what constitutes malice when it comes to the murder case. They sent another note about 90 minutes later, a note to the judge. The judge didn't say what it was, but he sent them back to deliberate more. And now they come back saying, hey, we want to go home for the night. So you think it's probably a split jury right now?
Yes, I think certainly I believe it's a split jury. I believe that before they got the case, when we discussed this the other day, that this was going to be a kind of a split jury deliberation room, where it's such a polarizing case that you're going to have people automatically on one side or the other. And so it's, not sure obviously what the split is, but being in that situation where the interesting thing is who the majority is, because a majority can sometimes weather down and beat down on the minority of jurors to have them come to a unanimous decision. And that's ultimately what the judge is trying to do, keep deliberating, ordering them dinner, putting them in the position to try to come back with a verdict.
No one is disputing that Rick Chow shot and killed Cyrus Carmack-Belton. That's not in dispute here. What is in dispute is the prosecution saying it's murder, the defense saying no, he was trying to protect his son. But the jury only has a choice here of finding him guilty of murder. They can find him guilty of murder or not guilty of murder, or we could have a hung jury. That's all that's on the table here, right?
The defense was very smart, in my opinion, to not ask for a lesser included offense of voluntary manslaughter. I believe had they done that, we'd have already had a compromise verdict. I believe where you have a big split like that, it's easy for them to compromise to a lesser included of voluntary manslaughter. And I believe that would have already happened. So I think it was very smart for them to do that, put them in the position where they are now. It's been 6+ hours, it seems, of deliberation. So from that, ultimately, it's a murder or nothing. It's all or nothing decision.
What did you make of the closing arguments earlier today?
Very good. I mean, Dale Scott is a well-seasoned prosecutor. I've tried a murder case against him. He's got a countless number of murder cases, and so and same for Sean Kent. Both are skilled advocates in the courtroom. Both are very powerful in being persuasion, and making sure their arguments are clear. I think it's just such a cut between, or with a dichotomy of you either believe that Cyrus Carmack-Belton pulled that gun and there was this withdrawal by Andy Chow, and the defense of others occurred where Rick Chow had to make that decision to save his son, or you don't believe it at all, and you believe that once Carmack-Belton tripped and fell, that the gun fell out, and even if he picked it up, he didn't point it, and that this is a situation where even himself, I think in kind of the rebuttal, Byron Gibson, the circuit solicitor, tried to reinstate that he would be the one who would feel like he needed to defend himself because of being chased. And it's such a difficult factual situation, and you got the legal issues as people watch the closing argument of having to decide for self-defense and defense of others, the elements of whether those apply, bringing on the difficulty. Does the chase itself just eliminate
Right.
that defense? Now again, the defense made the point, the chase is not illegal.
Right.
I don't believe the defense is really disputing that the chase was not smart and that they disagree that, or agree that they should not have chased him.
Mhm.
But that there is a second event that's most important. And the second event is, from the defense's standpoint, when the gun is pulled and pointed at Andy Chow. That, I think,
Right.
is the main issue, right? The linchpin of the defense's case is that is a separate event that is the most important thing for the jurors to decide.
And these jury deliberations, they could last well into the night, correct?
They could. So I've had 2 trials myself that had went into the night. One went back, and I think we got a verdict around 10 o'clock. Another one around 9:30 or so, the judge sent them home, and we started again in the morning, and they went to the afternoon.
Right.
So it's up to the judge. The judge has discretion of how long he's going to let them go. Obviously, they can send another jury note. It's completely up to the jury to make that call, and the judge in terms of what they're sending out. And a judge technically could let them go into midnight. So Judge Taylor has complete authority to make that decision. I don't believe he's going to let them go that long. They had just ordered them dinner. It was almost 7 o'clock. I think you got another 2 hours of at least deliberation before Judge Taylor maybe pulls the plug for today and makes them come back. But in terms of the defense, absolutely a situation where you do not want those jurors to go home.
Right. All right. Well, the jurors have been there since about 9:30 this morning, so already it's been a long day for the members of the jury.
They're worn out.
And now they're in a room, they're eating some supper, and they're arguing amongst themselves, trying to come up to a verdict here. So, yeah, I mean, we don't know a time frame here. Could it be 9 o'clock, 10 o'clock, 11? I guess we'll just have to wait and see.
The fact that it's 7, it depends what time they get their dinner. That's going to add another maybe 30, 45 minutes.
Sure.
I think you at least are going to 8 o'clock. The real thing is, once we start getting past 8 o'clock, that's where the time crunch really starts ticking at that point.
All right, Dane Phillips, criminal defense attorney, thank you for your input on all of this. And
Thank you.
Erica, we're going to be following this throughout the evening. Of course, as soon as we get a verdict or if we get some new details from the courtroom, we'll be passing along to our viewers both on air and online at WLTX.com. A quick break. We're back with more in a moment. right, you are looking inside the courtroom at the Richland County Courthouse. We understand that the jury has another note for the judge. Is this unusual? Our criminal defense expert, Dane Phillips, joining us now. Is this unusual? This would be their, let's see, first, second, third, fourth
Note,
time.
I believe.
Yeah.
It's not unusual. Now, once you start getting past 3 notes or so, that would be a little unusual. But jury notes in a murder trial, not unusual at all, especially when they're split in terms of kind of where we're stuck at this decision, you know, potentially going towards. If they come back in this jury note saying that they are split, what I would assume the next step will be the Allen charge given by the judge.
Well, I don't think we have any audio coming out of the courtroom just yet. Here comes the defendant. There's Rick Chow in handcuffs. They'll take him over to the defendant's desk. So it looks like we're getting all the parties in place here. The jury's been deliberating this case since right around 1 o'clock this afternoon, around 6 hours or so. And in case you're just joining us, about 90 minutes into their deliberations, they wanted to have the judge talk to them about malice when it comes to the murder charge. What do you suppose that was about? They're just trying to get a better idea about what they're trying to decide here?
Most likely it's a handful of jurors, you know, it could be even one juror. Somebody was stuck on needing to hear the law again related to malice. That means their focus was not on self-defense or the defense of others, elements that they needed to meet, but they wanted to hear what actually constituted murder in terms of malice, the ill will, the hatred. There's a specific definition of malice, and they wanted to hear that again. I wish the judge would have sent the jury instructions back so they could review them. I always prefer that, but I believe that's just a sign that they weren't sure what exactly malice meant and just needed to hear it again.
The defense team has not made it into the courthouse just yet, at least not into the courtroom. The prosecution, Byron Gibson and company, still sitting there, so nothing's happening in the courtroom just yet. So that was around 2:30. Around 4 o'clock, they sent a note to the judge. The judge did not read the note, but he sent them back to deliberate. Would you, as a criminal defense attorney, I guess you're speculating here, they were, what, telling the judge they were, what, at a standstill there or something?
Most likely, they're not supposed to say what their numerical split is, but sometimes they'll put that in the note. The judge definitely cannot ask what the numerical split is, but most likely they were telling the judge, we have a split. We're not on the same page.
And then around 5:55, some of the jurors wanted to go home, and instead the judge said, nope, not going to do that. There's a lot of media attention with this case. Going to keep you here, going to get you some supper, going to send you back to deliberate even more. But that was about an hour, roughly about an hour and a half ago. But here we are, an hour and a half later, and apparently there's some sort of note from the jury again.
And that was the right call, in my opinion, from the judge. This case is too charged, politically charged to send the jury home. Social media, significant others, family members, too many chances for there to be some type of third-party interference that could result in a mistrial. The judge made the right call to let them continue to deliberate.
Some ladies just walked into the courtroom. One of those women, the one wearing the glasses there, is the wife of the defendant, Rick Chow. She has been seen at the defense table several times during breaks in this trial. Joe McCullough, Jack Swerling still making their way into the courtroom. As we understand, they're not there just yet. So these proceedings are on pause for just a moment as we wait for the defense attorneys to come on in and find out what this latest note from the jury is. If they come back, Dane, if they come back here and they say, you know what, we're just at a standstill here, that's where something I believe you call the Allen charge is going to be read. Explain to our viewers what that is.
So the Allen charge is nothing but the name of a case from the United States Supreme Court. It's basically when you have a jury that is deadlocked, they're not agreeing with one another. The judge will tell them, I understand that you do not have a unanimous decision, and that's what's needed in the case, that basically all we'll end up doing is have a mistrial. We'll have another 12 jurors that'll hear the same evidence, will be put in the same position. Please go back there and see if you can come up with a decision. That you can have unconstitutional coercive Allen charges, so the judge has to be very very strict in what he reads out and how he reads it. And so in putting that Allen charge out there, we generally call that a dynamite charge because most of the time it works. It does get a verdict. However, if they come back and they still say they can't agree after an Allen charge is given, it's going to be declared a mistrial hung jury.
All right, Jack Swirling has made his way to the defense table. I believe we're waiting for Joe McCullough to come in. We could, I think Jack basically is saying 1 more minute. We'll see what happens here. And then we'll find out what this latest thing is. There's Joe McCullough now walking in. And they'll be turning the audio on in the courtroom in just a moment. We will listen in live and find out what's going on now as the jury continues to deliberate the fate of Rick Chow.
They're on their way, Your Honor. Yes, sir.
Okay.
Briefly, for just a moment, someone else is on their way.
Most likely the family of Carmack-Belton. And I would have to assume that's probably what she's referring to. The prosecutor, Stephanie Taylor's response.
Got it. So again, there's the wife of Rick Chow. She's wearing glasses in the courtroom there. If they do come back here and they say their hands are tied again and he reads them the Allen charge, how long do you think he will let them go tonight?
With it being 7:22, I think his cutoff time will probably be 9 o'clock. If I just a gut feeling from it, I don't think he lets them go much longer than that before he would send them home to come back in the morning. I don't think he'll let them go to 10, but I could be wrong. I've certainly had that experience myself. I've had two trials where the jury deliberated past 9 o'clock. So maybe, but not much more than that. Like you said, they're worn out. At 9 o'clock, they've been going for 12 hours. Right. So they started at 9:30. At some point, it does become too much. And so I think at that point, they'll be sending them home. I could easily see, if they get an Allen charge now, I could easily see us having a pretty good idea of what's going to happen in maybe an hour after that.
And if there's no Allen charge coming up here?
That'd be interesting. So if there's no Allen charge, it really will depend on what the note says at that point for me to provide any feedback. But if there's no Allen charge here, I mean, they're going to be able to just keep deliberating. And it could just be they're asking again to go home.
You know, to some observers, there's no question as to what happened here.
Glad to have everyone. I have another note. It's been marked as Courts Exhibit 23. Says, Judge, we request to hear your entire instructions to the jury. So they want to be completely recharged. You know, I don't know if I'll ask if they want to hear about, you know, the part about their duties and my duties and all that. They may. I mean, maybe where some of their, that's only a page. So I'll confirm with the foreperson that they want everything. And if so, we'll completely recharge.
Your Honor, we had earlier discussed with the prosecution allowing them the written instructions. I would now request that on behalf of the defense, instead of your reading them to them, send it back to them.
What's the state's position on that? Well, I mean, I think I have the discretion to do that, and I can tell you I've never done it. My concern, and I do, like I said earlier, maybe during the charge conference, I have some of my colleagues that do it. My concern is it's all supposed to be considered as a whole, and Mr. McCullough might like really what's on page 12, and Mr. Scott might like what's on page 16, and Mr. Swirling might like what's on page 24, and not going to look at the rest of it. That's the only concern I have with it. Well, if y'all are okay with it, I'll consider doing it.
What do you say?
They specifically asked for you to read it to them. I don't know if they knew they had an option. I mean,
And I'm happy to to work this out however y'all, I mean, I can ask them if they think it would be helpful if they had a copy.
Yeah, I think we'd be fine with that. That would help them.
My only concern, and it always was as a practitioner, that somebody zeroes in on one particular word instead of reading, the comprehensive charge. But I'm happy to entertain it and be convinced otherwise. No, about it.
No, I don't have anything to say about it. Your side.
Read this in again, is that right?
Yes, so the jury note is asking to be charged in full. In other words, they want to hear all of the judge's jury instructions again. That is interesting. That rarely happens this late in the game, to be recharged fully on the law. The defense has specifically said, asked just to send the written charges back to the jury, which I personally love and agree with. I always think they should go back. It appears that the state was initially hesitant to that.
That's what her preference would be. What if she wants us to bring it out, read the whole thing, if they want a section, or I can give you a copy and send it back, and let that be the foreperson's preference. I think all sides would agree that that would be the best way to handle it.
Everybody agree with that?
Whatever.
That's what the state agrees to that.
Okay. All right.
So both sides have now agreed. They're going to bring out the foreperson and ask, would they rather just be told and recharged by the judge, or to have the actual paper instructions sent back? I do think the paper instructions is helpful, because you have lay people who, they didn't go to law school, and these charges were read to them over the period of, say, 30 minutes. Being able to actually take the time and review the charges, in my opinion, is incredibly helpful.
All right, so what's happening now? Will the jury foreperson come in, or the entire jury?
They're sending only the foreperson, based on what I just heard. And they're going to ask, does the jury want to have the judge read them the law again, or do they want the written instructions sent back to the jury room?
Again, you say this is kind of unusual, right?
To be fully charged on the law in full, yes.
Hello.
Normally they have one specific thing.
Now, I'm going to ask you a few questions, and I want to make sure you understand. I don't want to know about anything going on back there.
Okay.
How people are voting, what they're thinking,
Okay.
who's tired. That is not anybody in this courtroom's problem. Okay? So we're clear on that. Your note says that you requested to hear the entire instructions again. Both sides, the state and defense, have asked that I inquire, number one, do you think you need all of it, or are there specific sections? And number two, do you think it would be, in lieu of that, be beneficial to have a copy of it for you all to review? And
We would love a copy. We thought we couldn't request a copy of it. Yes, we would much rather have a copy of it. We've been saying that for a long time, yeah.
Okay.
So that would be great. I thought that was one of the stipulations, is that we couldn't have
Well,
a written copy of it.
typically, my practice is that for various reasons, but the parties both suggested this and appear to have agreed to it. So
Okay.
I'm certainly willing to let the lawyers do their thing and make their decisions. So, all right, is everybody comfortable with sending back to copy?
I'm just not sure whether we should send 1 or 12.
I think a couple of copies would be fine.
Okay.
Mm-hmm.
All right. We will do that for you. If you can, hold on, if you want to head on back to the jury room, we'll get 3 or 4 copies
Okay,
made.
that's perfect.
And,
Thank you so
y'all
much.
keep working.
Okay, we are.
Dinner
Thank you,
should
sir.
be here shortly.
Okay, thank you.
All right, thank you.
Mhm.
Yeah, I had underlined the page where we were making some changes, or I think it was where something y'all wanted included that wasn't, or something I had changed, and I don't remember thinking, I think page 18.
Not as long as it's a clean copy, we're good. 2 clean copies.
Could I just suggest as few as possible, because I think the more that are out there, that wouldn't foster as much, group deliberation.
Well, let's do 3.
3 total?
Yep. You sure that was clean? It has no mark?
I'll watch it as it slowly goes through the feed, but it looks clean.
I did not want on this.
Yeah, I had marked that page because I knew there was going to be some discussion, and I don't want to see something I underline and think is more important than the rest of the charge.
Can we go on record about one matter, Your Honor?
Yes, sir.
And this is, and I think it still counts as contemporaneous, but we need to make sure when the solicitor was giving their rebuttal closing, I made an objection. And I don't think we ever covered and put that on the record. I think I contemporaneously to the solicitor mentioning pay apps on the phone specifically said, I think perhaps I should have gotten an expert. At that point in time, I made an objection. I asked to approach the bench. At the bench, I made an objection that there were, 1, no facts in the evidence that would suggest that there was a pay app on the young man's phone. Number 2, I stated that the witness on the stand was specifically asked about pay functions of the phone. And number 3 was very specific that there is no evidence whatsoever that has been turned over in discovery. As a matter of fact, I think this phone has gone through a Cellbrite analysis that there would have been nothing that would have shown that he would have had payability on the phone whatsoever. So at that point in time, I said that objection would have been. The analysis of the solicitor when he was making his closing argument, I said was impermissible at that time because he was putting facts that were not in evidence, not supported by any facts, and the solicitor would have had knowledge that there were no pay apps on the phone. And I made that objection contemporaneously. I just don't think I put it on the record.
Well, it would have been captured at.
I don't know if it was captured, but I just wanted to make sure.
Okay, well, I'll note that, and that I overruled your objection. I felt like the solicitor was arguing that there could have been, not there was, kind of thing. So but I'll note your objection.
Thank you, sir.
Maybe the slowest printer.
You're the loudest.
There's one right here. Can you make sure we got all 25 pages?
Numbered 1 through 27.
Footnotes that have just been inserted. The trial court shall not instruct the jury that malice may be inferred from the use of a deadly weapon, State versus Burnett, and then noting some matters appropriate for jury argument are not proper for charge.
We need scissors.
Yes.
Or white out Sharpie or white out.
I'd say scissors.
We can cut. Scissors? Get rid of it completely?
Or do you wipe one out and then just make another copy of page 15?
There are
There are several.
Several?
Yeah, you just need
All right, let's talk about what's going on now. They're making copies to send back to the jury room, a copy of the charge, is that right?
That's right. So the reason why, if you're watching this live and you see Madam Clerk using the scissors to cut off, at the bottom of these jury instructions were cases that were basically citing those pieces of law, and the jury doesn't need to see those cases and it's parenthetical explaining it because that would be improper. It can only be what was read directly by the judge to the jury. So they are cutting those parts off of the trial judge's instructions to the jury. I think they've agreed to send, or at least the judge made the decision, to send 3 copies of that back to the jury. And so it's a situation where they're going to be able to look at every piece of law that's been presented to them,
Right.
which is going to be a game changer. It could be good or bad for Rick Chow, because if you have this split in the jury and it's over the legal definitions of malice or the elements of defense of others or those things, they're now going to be able to walk through the law line by line, where before they heard it in 30 minutes and that was it. Now they're going to literally be able to go through it. And as we heard from the jury foreperson, they didn't believe that they had the ability to ask for it and that they desperately wanted it. And I do believe it's incredibly helpful for them. But however, it could kind of turn the tide for or against Mr. Chow, depending on where that split is.
She also said when they were asking about copies, she was basically saying two copies, which you can read a lot into that one way or the other. Are there a couple of people on the jury
Right.
that need to see this, or is she just trying to split the duties up with somebody else on the jury?
You probably could read into it that there's probably 2 individuals potentially that are really digging in. But again, that's all pure speculation. It could just be 2 camps of people, but it could be 2 specific people.
And as we speak right now, we understand some protesters have made their way outside the Richland County Courthouse. I just saw a photograph of one protester holding up a sign that says "Justice for Cyrus." Let me see what the other one says. And just looking at some photographs that I've just gotten into our information center, it looks like there's maybe a dozen protesters or so on Main Street outside the Richland County Courthouse right now with signs that say "Justice for Cyrus." So as the jury continues to deliberate, from my understanding, they're back into the jury room right now waiting for these copies. As the defense attorney Joe McCullough said a moment ago, how long does it take to get these things printed out? Slow printer or something, right?
Exactly. I mean, and again, that's another reason why the judge made the right call by not sending them home. You have protesters outside, all the type of potential improper influence that could happen if they were sent home. I certainly understand and agree why we need to push for a verdict today. Now, again, if they can't agree, the law is going to be clear. We need to have a mistrial hung jury.
We're at 7:40 here on a Monday night. They're going to get this delivered to them in the room probably in the next couple of minutes. Let's say we go to 9 o'clock. You just said tell the jury keep deliberating. All right, let's say we go to 9 o'clock and there's no decision. They come back, Your Honor, we're tied. We don't have a decision. Would he do the Allen?
Probably not. If it's that late, he probably will do the Allen charge in the morning.
Right.
And I actually think the case I was referring, one of the cases I've had that went that late was actually with Judge Taylor, and we went past 9 o'clock. And I want to say, if my memory serves me correctly, he did the Allen charge maybe that morning.
Right.
He waited, if I remember correctly. But I could see him waiting and not, because if you give them the Allen charge now, they're not going to remember it as much. Or whether if it comes back in the next hour, he may give them the Allen charge, then send them home. It just depends. You're right. If we cross that threshold of 9, I would imagine he waits and does it in the morning.
Well, by then the jury will have been at the courthouse for about 12 hours.
Yes.
And again, the breaking news right now, as the jury continues to deliberate, a small number of protesters have gathered outside the Richland County Courthouse on Main Street in downtown Columbia. demanding what they call justice for Cyrus. As we watch the defense team gather their belongings, and Rick Chow will be put back in handcuffs there. He'll be taken back to the holding room as we await another update from this jury. As always, you can continue to follow what's going on inside the courtroom, both on air and online at WLTX.com. We'll be back with another update as soon as we get one. We are back on the air because we understand there is a verdict now, a verdict in the case of Rick Chow, who has been on trial for murder in the death of 14-year-old Cyrus Carmack-Belton. This is about 7.5 hours now into the jury deliberations after 4 different questions to the judge in the case. We have a verdict. Our criminal defense attorney expert with us now, Dane Phillips. A verdict. What's your take? We don't know what that verdict is just yet.
We don't know. I would say if you're asking gut feeling, it's probably leaning towards guilty, just given my experience, given what's there. However, you never know. It's always a surprise, and that anxiety that trial lawyers have. I've obviously been in this situation many times, and when you get that text that there's a verdict, you know, the heart starts beating. And so even though you may think you know what it's going to be, there's always the anticipation of the unknown. And so as we wait for the defense team to get into the courtroom, that's the thing, without them there, I mean, obviously everything is on hold. And so, but if you had to put money on it at this stage, I would say it's leaning towards guilty, where I felt like this case from the beginning was a hung jury mistrial type case. Getting a verdict back, certainly they've deliberated for 7.5, 8 hours.
Again, that verdict.
Significant amount of time.
Yeah, we're just getting word that there is a verdict in the case of Rick Chow. So we're waiting for the defendant to get back to the defense table. We are waiting for the defense attorneys to also make it back before the jury will come in, and we'll find out what that verdict is. Dane, the longer this went on, though, the longer you thought it was a benefit to the defense, correct?
100%. So in a trial, anytime you get a quick verdict, generally that leans against you. I'll tell you that it's a situation where the longer a case goes, the closer you are to a hung jury mistrial, which for the defense attorney is a win. The longer a case goes, that shows that the jury's really deliberating, really mulling over the decisions they have to make, that there's not an agreement, because you got to have a unanimous verdict regardless. And so that's always the issue, is fighting for you know, a unanimous verdict, and that's kind of the big part. And hopefully they don't. Okay.
Here comes Rick Chow now in the handcuffs, coming from the holding room. And they will place him at the defendant's table, and in just a few moments the jury will come in and we will find out the verdict here. Is Rick Chow guilty of murder in the killing of Cyrus Carmack-Belton? Did the jury return a not guilty verdict? Because basically if they've got a verdict, Dane, it's either going to be guilty or not guilty, because there was no manslaughter charge to choose from here.
That's right. It's all or nothing. The defense did not want any lesser included offenses. The judge didn't charge them on that, so it's murder or it's either guilty or not guilty. It's murder or nothing, and so certainly high stakes decision by the defense team to do that. I do think if this case had a lesser included offense of voluntary manslaughter, that there's a significant likelihood they would have compromised to that much sooner than this.
Let's talk about what happens here if the jury comes back and they say this is a guilty verdict. Could he be sentenced tonight?
Yes, the judge can go into sentencing tonight. Given the time, I would anticipate there's a good, reasonable belief that the judge would just do sentencing tomorrow morning.
Mm-hmm.
There's no need to hurry that process. Given how late it is in the evening, if it is a guilty verdict, I could see sentencing first thing in the morning.
And if it's a not guilty verdict, he will be released, what, immediately?
He will. It's a situation where they will have to, there's some steps they have to go through, obviously, but yes, he would be released. He'd be free.
One of the defense attorneys, Joe McCullough, there just spoke to Rick Chow, and the expression on his face, I think he's thinking along the same lines you are, but again, this we don't know for sure. This jury could come back one way or the other. We just don't know until we hear their verdict in the courtroom. We're waiting on Jack Swirling, the other defense attorney, to make his way back into the courtroom. There comes the wife now of Rick Chow. You see her there wearing the black jacket as she makes her way in as well. As we await this verdict, this jury has been deliberating since 1 o'clock this afternoon, following some pretty intense closing arguments from earlier today. The prosecution making their case